to have with us honorable judges of the Orissa High Court who have spared their valuable time to be with us here today. My lords, our heads bow down in gratitude for your lordship's gracious presence on this august occasion. On this momentous occasion, we are fortunate to have with us Srimati Shubha Sharma, IAS, Commissioner cum Secretary to Government of Odisha, Department of Women and Child Development, Bhubaneswar, Sri Aravind Agarwal, IAS, Director, Integrated Child Development Services and Social Welfare, Bhubaneswar, Director, Public Prosecution, Additional Director, Judicial Academy, Judges of Pocso Courts, Principal Magistrates, Juvenile Justice Boards, Secretaries of District Legal Services Authority from across the state, Members of Registry, the Public Prosecutors of Pocso Courts, Chairpersons of Child Welfare Committees, Mr. Sugata Roy, UNICEF Odisha, representatives from Special Juvenile Police Unit, District Child Protection Officers, District Social Welfare Officers, members from one-stop centers, medical practitioners, officers from State Institute of Rural Development, State Council of Educational Research and Training, and representatives from NGOs and civil society organizations, dignitaries from different departments of the Government of Odisha, members of Bar, members of print and electronic media, delegates, and judicial officers who are all present today. May I now request my Lord, Honorable Sri Justice Debabrata Das, Judge and Chairperson Juvenile Justice Committee, Orissa High Court, to kindly adorn the dais, and I request Registrar General to kindly conduct his Lordship to the dais. I now request my Lady, Honorable Miss Justice Savitri Ratha, Judge and Member Juvenile Justice Committee, Orissa High Court, to kindly adorn the dais, and I request Registrar Vigilance to kindly conduct her Ladyship to the dais. May I now request respected Srimati Shubha Sharma, IAS, Commissioner cum Secretary, Department of Women and Child Development, Government of Odisha, to kindly adorn the dais, and I request Coordinator Arbitration Center to kindly conduct our esteemed guest to the dais. May I now request Sri Sugata Roy, Officer in Charge, Chief Field Office, UNICEF Odisha, to kindly adorn the dais, and I request Registrar Judicial to kindly conduct our esteemed guest to the dais. As a mark of our heartfelt gratitude, may I now request Judicial Officer Mrs. Pranati Shah to kindly present a flower bouquet to His Lordship, Honorable Sri Justice Debabrata Das, Judge and Chairperson Juvenile Justice Committee, Orissa High Court. May I now request Judicial Officer Mrs. Janaki Biswal to kindly present a flower bouquet to my Lady, Honorable Miss Justice Savitri Ratha, Judge, Orissa High Court, and Member, Juvenile Justice Committee, Orissa High Court. I now request Judicial Officer Sri Srujan Saraswat to kindly present a flower bouquet to our respected Srimati Shubha Sharma, IAS, Commissioner cum Secretary, Department of Women and Child Development, Government of Odisha. And I now request Judicial Officer Sri Kumar Spandan to kindly present a flower bouquet to respected Sri Sugata Roy, Officer in Charge, Chief Field Office, UNICEF Odisha. May I now seek the permission of the Honorable Chair to kindly declare the event as open. Thank you, my Lord. We shall now begin the program by rendering the national anthem. Ladies and gentlemen, I now request all the dignitaries on and off the dais and the audience to kindly rise as a mark of our respect for the Yatha suryastata jnanam. Knowledge is like light as it drives away darkness, that is ignorance. As a mark, light is a mark of auspiciousness, and to make this program a blessed one, we would like to invoke the Almighty at the very beginning of this event. May I now request my Lord Honorable Sri Justice Debabrata Das, Judge and Chairperson, Juvenile Justice Committee, Orissa High Court, to kindly light the ceremonial lamp. I also request all the dignitaries on the dais to kindly join the lighting ceremony. As we begin the inaugural session, I now request my Lord Honorable Sri Justice Debabrata Das, Judge and Chairperson Juvenile Justice Committee, Orissa High Court, to kindly present the welcome address to the august gathering.
A very good morning to all of you who are today in this state level consultation on effective implementation of the provisions of the Pocso Act. Honorable Sister Justice Savitri Ratha, all other brother judges of the High Court who are present, including the members of the High Court Juvenile Justice Committee, dignitaries like the Secretary of the Department of Women and Child Development, Madam Sharma, dignitaries from all other departments of the state, Registrar General and other officers of the registry, Member Secretary, State Legal Services Authority, Director Public Prosecution, Director Judicial Academy, and all others who are present today, the stakeholders who have come for the consultation, that is the presiding officers of the Pocso courts, the members of the chairperson and members of the JJVs, and other public prosecutors of those courts who are functioning there, the members of the print and electronic media, ladies and gentlemen. It gives me immense pleasure in welcoming all of you to the state level consultation 2022 on effective implementation of the Pocso Act. Effective implementation of the Pocso Act is a matter of utmost significance for the whole nation, including our state. The Constitution of India guarantees fundamental rights to all children in the country and empowers the state to take special provisions for their protection and development. The Constitution of India and the United Nations Convention of the Rights of the Children put obligation to make laws to promote and protect the rights of all children across the country. The Act is a comprehensive law for the protection of children from several sexual assault, sexual harassment, and pornography, while safeguarding the best interest of the children. The Protection of Children Act has come into force from the year 2012. This year is 2022 and we are completing almost 10 years of coming into force of the said act. Thus, it is important for us to take a review of its implementation and how far we have achieved the objective and goal and where we stand today and what should be the future plan of action to march ahead. The state consultation would give a complete opportunity to all the stakeholders associated with the act to identify good practices, gaps and identify critical actions for effective implementation of the act, the impediments and how with our coordinated and conjoint effort we would reach and march forward. The improvement of the system is a gradual process which requires continuous follow-up, for which I appreciate the impeccable enthusiasm and commitment of all the stakeholders facilitating in preserving, promoting and safeguarding the rights of children and working passionately for the effective implementation of the Pocso Act. Children are the world's most valuable resource and its best hope for the future. Children are the most precious and significant part of our society as they are our future. They need a protective, positive and favorable environment devoid of any violence, abuse, exploitation to grow into adulthood. They are all invaluable asset of the society and vital to the nation's present and the future. We are aware that children by virtue of their age are vulnerable to many risks, but as stakeholders working for children in different circumstances, we are also aware that children in adversity are particularly more vulnerable to a plethora of risks. Child sexual abuse is on the rise all over the world and particularly in our own country. In many ways, Indian criminal law appeared inadequate to deal with such sensitive issues. That is the reason we have with us the Pocso Act presented by the legislature. Pocso Act was put in place to make it easier for victims of sexual abuse to seek justice and for quick and speedy rendering of justice. As the children are sensitive and capricious, they can easily be abused, exploited and neglected. Thus, all the children who are should be best on primary consideration that they are in the best interest of the child. Child welfare committees, Pocso courts, JJBs are essential statutory bodies. They have a duty to make sure that the children receive the legal aid, receive immediate compensation in coordination with the state, with the legal services authorities. It is believed that the children who experience sexual exploitation have long-term stress issue on the family. So the family, parents, relatives, NGOs can play a major role in preventing the abuse amongst them and give them proper education. The mental health of millions of children worldwide has been put at risk due to sexual abuse. It is imperative to have trained counselors, psychologists, tutors and social workers. Also, there is a need to post committed police officers in SJPUs so that the investigating agencies are sensitive enough to understand the causes of children in conflict with law. Further, adequate trainings to be given to all those associated with children related issues, as it is quite sensitive to deal with children. With the continuous efforts, the different departments of the government of Odisha together with UNICEF is committed to make the state a better place for the children. Further, the Juvenile Justice Committee of the High Court of Orissa has been regularly monitoring and authorities and institutions associated for effective implementation of the Act. I urge our resource persons and participants to not only stress on the conceptual understanding of the Act, but also discuss the implementation strategies, good practices developed, the gaps, the challenges and the solutions to overcome the challenges and gaps. in marching ahead to achieve the avowed and noble objective of the legislation for achieving the ultimate goal. We are extremely hopeful that this consultation is going to be much more meaningful. I would seek all your support in making it a memorable and successful event. I am sure that you all will feel enriched with knowledge after completion of this event. I welcome you all once again to the consultation and hope that you will have a great time. At the end, I must say, the woods are lovely, dark and deep, but we have promises to keep and miles to go before we sleep. Miles to go before we sleep. Thank you. Vande Utkala Janani.
Thank you, my lord, for your warm and heartfelt welcome. I now request respected Srimati Shubha Sharma, IAS, Commissioner cum Secretary, Department of Women and Child Development, Government of Odisha, to present the inaugural address and opening remarks to the gathering.
Honorable Justice Debabrata Dash, Honorable Justice Madam Sabitri Rathore, all other senior judges of Odisha High Court in our midst, Pocso Court judges, Shri Ray, Odisha's Chief of Field Office UNICEF, senior officials of the Government of Odisha from different departments, chairpersons of child welfare committees, public prosecutors, civil society members, friends from the media, ladies and gentlemen. Good morning to all of you. I am privileged to stand before you today to share with you some of the work that has been done by Government of Odisha, and in continuation of what Justice Dash said, mention to you what are our expectations or needs from this state level consultation on Pocso Act. Bill Clinton once said, "There is nothing more important to our future than the safety of our children." These simple words summarize the essence of why we are meeting today in this state level consultation. The Government of Odisha, with the help of all stakeholders who are present in this hall today, has taken certain path-breaking initiatives on protection of children. The issue has been looked at from a multidimensional prism of health, nutrition, safety, and education. Just last evening, the State Cabinet approved Prarambh, a policy for the comprehensive well-being of children that addresses 7 components, including the ones that I mentioned before. In the area of child protection, Odisha is a pioneer in the country with regard to creating a protective environment for children. A strong network of institutional mechanisms has been created. The Odisha State Child Protection Society, led by a team of professionals, is implementing the Pocso Act and Juvenile Justice Act through district child protection units in every district. There are 31 child welfare committees, 34 juvenile justice boards, 36 special juvenile police units which are fully functional in the state. 12 child-friendly children courts have been developed by the department, and another one is going to be functional very shortly. Besides, designated Pocso courts have been made functional for timely disposal of justice to the children. The Odisha Commission for Protection of Child Rights is also monitoring the implementation of the Pocso Act, and I am glad that the chairperson has been able to find time and join us today in this consultation. 36 special juvenile police units comprising of child welfare police officers from each police station, 2 social workers from the DCPU, and headed by a DSP rank officer are functional today. There are more than 230 child care institutions, which include both children's homes for long-term institutionalization and open shelters for short-term institutionalization. These are functional and are providing quality care to about 8,500 children who are in need of care and protection or in conflict with law, under the regular supervision of the judiciary. These also include 121 Pocso victims. All these institutions are supported with the soft components of outreach, response, and rescue services. As Honorable Justice Dash mentioned, we have managed to create a pool of trained counselors from multiple agencies under the Women and Child Development Department, such as DCPUs, family counseling centers, and they work in coordination with the district mental health program to provide psychosocial support to the victim children. Similarly, Childline 1098 and then 181 Women Helpline Services, one-stop centers, and other similar machinery provide the much needed support for fulfilling the health, legal, emotional, and other needs of the victims. As per the provisions of the Act, CWCs are empowered to declare support persons for the victims as and when required. For ease and convenience, a comprehensive database of support persons has been prepared, and CWCs are engaging these support persons for the victim and his family or her family whenever needed. Similarly, there is a directory of interpreters and translators which has been developed at the district level and is used by different agencies on need basis. Along with the agencies which are working directly under the administrative control of the Department of Women and Child Development, we are extremely grateful to receive timely and regular support from other stakeholder departments. State-run hospitals and medical institutions provide 24/7 care, treatment, and also support in examination of victims, which becomes so critical when legal action has to be taken. Teachers of the school and mass education departments are trained on the subject matter, and continuous efforts are made to create awareness as well as to ensure uninterrupted education to the victim children. However, we all know that unless the target group of children and their families, as well as the officials involved in the entire process under Pocso Act, are empowered with this information, we cannot achieve our goal of creating a child-friendly, safe society. To this end, there has been a continuous IEC campaign in the state, supported by our partners, UNICEF and other civil society organizations. Capacity building of functionaries and different stakeholders has been taken up at regular intervals in collaboration with UNICEF, Kailash Satyarthi Foundation, ActionAid, and reputed academic institutions of Odisha, such as the Odisha Judicial Academy, where we are today, the National Law University of Odisha, Gopabandhu Academy of Administration, Biju Patnaik State Police Academy, etc. The state is also implementing a number of schemes which have protection and empowerment of children as their core mandate. Some of these are Biju Sisu Suraksha Yojana, Advika, Every Girl is Unique, Beti Bachao Beti Padhao, Biju Kanya Ratna Yojana, among others. In addition, the Department of Women and Child Development partnered with the Home Department and led the successful Pari Pai Kathati campaign. Meetings with civil society, media persons, police officials, lawyers, PRI members, children and their families are conducted at regular intervals. Caravans have been launched, posters, banners, hoardings have been installed, radio jingles and panel discussions on TV are also telecast. Multiple conferences and consultations for cross-pollination of ideas and more effective implementation of laws for protecting children have been taken up. All these initiatives help in community mobilization and public sensitization on a topic which otherwise does not get a lot of attention and which most people are very uncomfortable discussing. We know that all societies have a soft corner for children. Crimes under Pocso shake us from within because it is the destruction of an innocence that can never be regained. It is an attack on a helpless victim who at times is unable to even comprehend the magnitude of the crime. While we have done an appreciable amount of work, yet there are lots of gaps that need to be bridged. It is true that we have set up institutions for childcare that are doing excellent work, but it is also important that they are equipped with skills to deal with issues in a child-friendly approach. We have good care facilities and CCIs, but we need to endeavor to make them world-class institutions that look at reintegration of Pocso victims back in society. In most cases, we are working as a team, supplementing and supporting each other's work. But still, there is need for greater coordination among different stakeholders engaged in this work. While more and more people today are aware of Pocso Act and the protection that it affords, we still need to reach even the most interior village and hamlet of Odisha. Above all, we need to create an environment that accepts the victim child and tries to address the child's mental trauma and removes the social stigma that is attached to it. These are questions to which none of us as individuals have answers. Yet, with our collective experience of more than 3,000 years in this hall today, we are in a position to devise solutions. We know that an act is only good as it is implemented in the field. Otherwise, it can remain a piece of legislation. I am grateful to the Juvenile Justice Committee under the leadership of Justice Dash, who has shown us the way on the need for introspection and reform from within. The challenge now is upon each one of us to work together today to brainstorm and provide valuable feedback which would enable the committee and the department to guide and strengthen the existing system for child protection. With these words, I would like to welcome you all once again and request for your active and wholehearted participation. Thank you. Jai Hind, Jai Jagannath.
Thank you, ma'am, for sharing your valuable thoughts and also enlightening us about the effective steps being taken for the effective implementation of the Pocso Act. May I now request respected Shri Sugata Roy, Officer in Charge, Chief Field Office, UNICEF, Odisha, to present the keynote address to the August gathering.
Respected dignitaries on the dais, Honorable Shri Justice Debabrata Das, Chairperson, Juvenile Justice Committee, High Court of Orissa, Honorable Ms. Justice Savitri Ratho, Member, Juvenile Justice Committee, High Court of Orissa, Srimati Shubha Sharma, Commissioner cum Secretary, Department of Women and Child Development, Government of Orissa, Judges of High Court of Orissa, Judges of Pocso Court, Senior Officials of Government of Orissa, Chairperson, Orissa State Commission for Protection of Child Rights, Chairperson of Child Welfare Committees, members of media, ladies and gentlemen. I would like to start by thanking the Juvenile Justice Committee of High Court of Orissa for bringing us together to deliberate on this important topic. Protecting children has been one of the top priorities of the state, and it is heartening to witness that judiciary along with Women and Child Development Department, Government of Orissa, is taking a lead role in promoting and protecting children's rights and their well-being. Protection of Children from Sexual Offences Act 2012, which is popularly known as Pocso, is a gender-neutral legislation, and it is one of the most progressive and comprehensive law that safeguards the best interest of the children by incorporating child-friendly mechanisms for reporting, recording of evidence, investigation and speedy trial of offences through designated special courts. In Orissa, a substantial progress and commitment has been exhibited by the state through sustained investment in strengthening the systems and structures. There are many such examples of state's commitment, but I would briefly state a few that are milestones for protecting children from sexual assault and harassment. There are functional POSCO courts in the state. Orissa is investing in child-friendly police stations across the state. Recently, about 16 such police stations have been set up by Crime Against Women and Children Wing of Orissa Police. To tackle with children's issue, a separate wing, Crime Against Women and Children, has been set up under the crime branch. The Women and Child Development Department has set up one-stop centers across the state to prevent violence against girls. The district child protection units, child welfare committees and other services delivery structures are functioning in the district. The Anganwadi workers have been identified as a cadre for children's protection and adolescent empowerment through the schemes like Advika. The Sampark Help Desk, recently launched under the Crime Against Women and Children Wing, is reaching out to children who have been sexually abused. Through this help desk, psychosocial support is being provided to children and caregivers. Through telecounseling, caregivers and children are being connected with stakeholders and information about entitlement is shared. All these initiatives reflect state's strong commitment towards protecting children. It's quite unfortunate, despite all these measures, there is an increasing trend in data for sexual abuse and harassment, though it reflects that there is a growing awareness among people who are now accessing the services and structures to report offenses. But in the context of children who have been sexually abused, we have a long way to go for shifting the perspectives. There is a need for building a movement to bring about an attitudinal and behavior change towards the survivors of sexual abuse is an important aspect. Though we are witnessing an increased awareness in media, including social media, on the aspect of reporting, however, aftermath for the child to live in the same place around the same people with pre-existing notion on sexual abuse is a big challenge. We need to address it by creating a safe space and enabling environment for children. Lastly, an important point of discussion across regional workshops have been on how the systems deals with cases of consensual relationships between adolescents. Defining an age of sexual consent is important, but resorting to legal proceedings at a time when young people have discovered love and sexuality is not always in their best interest. We note with growing concern that many cases in Pocso are consensual and leading to a victimization of both girls and boys. Evidence exists about devastating effect this has on the lives of many young girls and boys. I am sure this workshop will bring about those discussions like expediting the disposals, move to more timely submission of investigation reports, enhances medico-legal proceedings, bringing about increased compensation to the children, enhancing the psychosocial support that children require, and other related issues. Today's workshop has been designed in participatory manner and will definitely be helpful to recognize the procedural bottlenecks for children's journey to justice. I am certain that communications and solutions coming in today will reach the field. At all stages, UNICEF commits to support the agencies and the government and make collaborations for child rights. Thank you.
Thank you, sir, for enlightening us about the steps being taken for protection of children from sexual offences. As we now proceed to the end of the inaugural session, may I now request Honorable Ms. Justice Savitri Ratha, Judge, Orissa High Court, and Member, Juvenile Justice Committee, Orissa High Court, to deliver the vote of thanks.
Namaskar and a very good morning to everybody. Children are the world's most valuable resource and its best hope for the future, said the late American President John F. Kennedy. The future of a country depends on how its children are being nurtured, as they have a significant role to play in its betterment. As children are the most vulnerable group in the society, they need extra protection to develop and grow in an atmosphere which is free of violence, especially sexual violence. The year 2022 completes 10 years of implementation of the Pocso Act, which was enacted with the objective of protecting children from various sexual offenses. The provisions of the Pocso Act were formulated with the intent of protecting the children from a wide range of sexual offenses and deterring the commission of such offenses and introducing a child-friendly judicial procedure and mechanisms. The Act is a comprehensive legislation that safeguards the interests of children by incorporation of child-friendly mechanisms for reporting, investigation, recording of evidence, and speedy trial of offenses through designated special courts. The Act is gender neutral and it prioritizes the child's best interests and welfare at all stages. The effective implementation of this Act, however, requires a coordinated effort among all the stakeholders, be it the investigating agency, prosecutors, courts, medical practitioners, etc. And for effective implementation, it is very important to create a platform for multiple stakeholders to identify good practices, gaps, and critical actions with a focus on restorative justice and victim-centric approach. It is imperative to create greater sensitivity and awareness on the issues of child sexual abuse among all, and to rehabilitate survivors whom society has not been able to protect. The Constitution of India guarantees equal rights to all its citizens, including children, so their childhood should therefore be free of exploitation and violence. I feel honored and privileged to have been given this opportunity to propose a vote of thanks on this special occasions. First of all, I extend my hearty gratitude to our Chief Justice, Dr. S. Muralidhar, without whose encouragement this consultation could not have been thought of. And I thank all my esteemed brothers who have spared the time to be with us, and their presence has is the source of inspiration for us and all the other participants in this consultation. I thank my brothers in the Juvenile Justice Committee who have also spared the time to be with us and encourage all the participants. I thank the Commissioner, cum Secretary, Government of Orissa Women and Child Department, Women and Child Welfare Department, Madam Shubha Sharma, for reminding us of the challenges ahead of us and also participating in this inaugural ceremony. I thank the Director ICDS, Shri Arvind Agarwal, for making this consultation possible. I also express my gratitude to Mr. Sugata Roy, Officer in Charge, Chief Field Officer, UNICEF Orissa, and of course Mrs. Tanisha Datta, who has also spared time to be with us today, and the entire team of UNICEF for extending their wholehearted support for making the consultation possible and for the presence in this inaugural ceremony. I also extend a vote of thanks to the officials from different departments of the Government of Orissa, like the Department of School and Mass Education, Home Department, Department of Health and Family Welfare, Department of Crime Against Women and the Children's Wing, and the Biju Patnaik State Police Academy for their support in organizing this consultation. I also thank the resource persons and the experts who have agreed to participate in this consultation and whose valuable inputs will be of immense benefit to the participants. I have a long list, so I'm just making sure that I don't miss out anybody. I also thank I thank Mrs. Neha Naidu, Child Protection Specialist, and then for being present here. And I extend my vote of thanks to the chairperson of OSC PCR for gracing the occasion. I extend my vote of thanks to the Registrar General and the entire members of the registry for their cooperation and hard work for making this consultation possible. I also extend my thanks to the Director Public Prosecution for his support, and to the Director Odisha Judicial Academy and his team for making this consultation possible and making all the arrangements for the guests and the invitees. I also extend my thanks to the Member Secretary, Orissa State Legal Services Authority, and his team for the support in organizing this consultation. And I mustn't miss out Mr. Abhilash Senapati, Secretary Juvenile Justice Committee, High Court of Orissa, and members of the Secretariat and other members of the team for their relentless and untiring efforts to make this event a success. I convey my gratitude to the participants, the Pocso Court judges, the PM JJBS, the Secretary, District Level SAs, and the public prosecutors, chairmen of the CWCs, representatives from the Special Juvenile Police Unit, the DCPOs, the DSWOs, members from one-stop centers, medical practitioners, officers from the SIRD, SCERT, and representatives from the NGOs and civil society organization. I also express my gratitude to all the other dignitaries and guests present on this auspicious occasion. Your presence has instilled positive energy in us. I also thank the members of the print and electronic media and all others who have toiled hard to make this function a great success. I may be excused as I may have missed out the names of some persons without whose cooperation, support, and participation this consultation would not have been possible. I therefore thank and extend my gratitude to everybody who has made this consultation possible. And it is indeed appreciable that the Juvenile Justice Committee is actively involved in monitoring the juvenile justice institutions and disseminating knowledge through consultations, training programs, and seminars. Also, all the stakeholders in the untiring endeavor have worked together in preserving, protecting, and promoting the rights of children. I would like to end by quoting what Nelson Mandela once said: "There can be no keener revelation of a society's soul than the way in which it treats its children. So let us renew our pledge to care for, nurture, and treasure our children who are our future." Thank you. A good day to all of you.
Thank you, my lady, for your kind and gracious words. May I now seek the leave of the honorable guest to kindly wind up the inaugural session. Thank you, my lord. I request all the honorable guests, dignitaries, and participants to kindly proceed to the portico of the Academy for a joint photo session. May I now request Honorable Sri Justice M.S. Raman, Judge and Member, Juvenile Justice Committee, Orissa High Court, to kindly adorn the dais, and I request Deputy Registrar, Administration and Protocol to conduct his lordship to the dais. As a mark of our heartfelt gratitude, I now request Judicial Officer Srimati Alpana Swain to kindly present a flower bouquet to His Lordship, Honorable Sri Justice Sangam Kumar Sahu, Judge and Member, Juvenile Justice Committee, Orissa High Court. May I now request Judicial Officer Srimati Pranati Shah to kindly present a flower bouquet to Honorable Sri Justice A.K. Mahapatra, Judge and Member, Juvenile Justice Committee, Orissa High Court. And I now request Judicial Officer Srimati Janaki Biswal to kindly present a flower bouquet to Honorable Sri Justice M.S. Raman, Judge and Member, Juvenile Justice Committee, Orissa High Court. Thank you. May I now seek permission of the Honorable Chair to begin with the session. Thank you, my Lord. As we begin the technical session, we have with us, my Lord, Honorable Sri Justice Sangam Kumar Sahu, Judge and Member, Juvenile Justice Committee, Orissa High Court. May I now request my Lord to kindly present the opening address. My Lord, please.
হ্যালো এইটা অন আছে তো Good afternoon to all my esteemed brothers on the dais, Honorable Justice A.K. Mahapatra, Justice M.S. Raman, and of the dais and my esteemed sister, members of Registry of Orissa High Court, Director in Charge, Orissa Judicial Academy, learned Pocso Act judges, Principal Magistrate, Juvenile Justice Boards, Secretaries, District Legal Services Authority, Public Prosecutors, Chairpersons of Child Welfare Committee, representatives from Special Juvenile Police Unit, District Child Protection Officer, District Social Welfare Officers, members of one-stop centers, medical practitioners, officers from State Institute of Rural Development, State Council of Educational Research and Training, officers from UNICEF, representatives from NGOs and civil society organization, Professor Madam Ved Kumari, Vice Chancellor, National Law University, Odisha, Mrs. Preeti Patkar, co-founder and director of organization Prerana Mumbai, other distinguished guests, resource persons, members of print and electronic media, ladies and gentlemen. At the outset, I must appreciate the tremendous effort put by the Juvenile Justice Committee High Court of Orissa, in collaboration with the Department of Women and Child Development, Government of Orissa, UNICEF, Orissa, in organizing this state level consultation on effective implementation of Pocso Act in this August Gati Krishna Mishra Auditorium. All of you know that the increasing numbers of sexual offenses committed against the children that resulted in the enactment of Pocso Act, which came into force on the Children's Day of the year 2012. Right to privacy and confidentiality of the child has to be protected and respected by every person, by all means, and through all the stages of judicial processes involving a child, and the best interest and well-being of a child at every stage are of paramount importance, and it is the duty of the court and all concerned to provide a healthy physical, emotional, intellectual, and social environment to the holistic development of the child. After inaugural session, there were group discussions on each of the 4 themes at separate places. The selection of themes was excellent, and I personally spent some time in each of the group discussion. And I found that the presentation and the interaction between the resource persons and the participants was very encouraging. And now we have reached at the stage of technical session. All of you must have heard about Samudra Manthan. So likewise, we had Manthan on all these 4 topics. So let us see what Amrit came out of it. So we'll have a presentation on each of the themes for 15 minutes. And please stick to your time. That is, I will request you, and then we'll go to the question and answer on each of the themes. And I'll say that obviously that if anyone wants to put any question on a particular theme, he should or she should mention his name, designation on the theme in which he or she wants to put the question, and specific questions should be mentioned, and that should be forwarded in advance, so that only few selected questions will take off because of paucity of times, and then there will be address from Mrs. Preeti Patkar and Professor Ved Kumari on specific topics. Then there will be a open house discussion, and so let us now begin, and please.
Thank you, my lord, for your valuable thoughts. With this, we move on to our next segment, that is presentation by the groups. The presenters of the thematic groups, Group A, B, and C, and D, will be giving presentation as per their themes. I request the presenters to kindly limit their time to 15 minutes due to time constraints. Furthermore, the audience who would like to put questions to the presenters may write their name, designation, theme, and the specific question on a paper and submit the same to our additional director, Odisha Judicial Academy. Thereafter, at the end of the presentation by all the groups, the questions will be answered by the presenters according to the theme. Starting with theme 1, I request the presenters of Group A to present on the topic Rehabilitation and Reintegration of Pocso Survivors and Preventive Measures, Practices, gaps, and opportunities. I request the presenters of Group A to kindly come to the dais and present on the topic. We'll be starting with Group 2. The topic is child-friendly court procedures during prosecution for Pocso survivors, practices, gaps, and opportunities. I request the presenter of Group B to kindly come to the stage and present on the topic.
Please come. And group 1B, make themselves ready for the.
Next page.
Yes, right.
Namaskar. Myself Romeo Mahapatra, District Child Protection Officer Devgarh, and with me Sri Dilip Kumar Malik, Public Prosecutor from Denkanal, and DSW Madam. Welcome from the group of group number 2. I request Sri Dilip Kumar Malik to introduce the topic.
The Act provides for child-friendly pre-trial procedures to minimize the trauma felt by child victims and to eliminate the possibility of re-victimization at the time of trial. The child-friendly pre-trial procedures cast duties on the police and are to be implemented at the time of reporting of offences and recording of the child's statement. These are given in detail in sections 19 to 26 of the Act. Under section 12C of the Legal Services Authorities Act 1987, every child who has to file or defend a case shall be entitled to legal services under this Act. The Pocso Act 2012 confirms the right of free legal aid under section 40, and this Pocso Act is gender neutral. Next, progresses made so far. As of now, we have 23 numbers of dedicated Pocso courts in 23 districts of our state. In rest of the 7 districts, additional district judges have been designated to try such cases. Besides, we have in our state 21 numbers of fast-track special courts to try such cases. In all such courts, special public prosecutors have been appointed to conduct such cases from the side of the prosecution. In all the 30 district headquarters, we have special provision for vulnerable witnesses to depose. They are used by Pocso courts for recording of evidence of the victim. Best practices. Courts are now empowered to award compensation to Pocso victims directly. Less dependence on DLSH has eased the process of grant of compensation. Interim compensation amounts are granted in appropriate cases even before conclusion of the trial. DCPUs in many districts are nowadays invited to high-level meetings at regular intervals to discuss issues relating to Pocso cases. Now, the critical gaps.
We have identified some critical gaps also. Number one is that non-reporting of early pregnancy cases by some institutions such as Ma Gruha and some private nursing home also. Some Pocso cases, child abuse cases are remained unreported. Second thing is the contradiction between the implementation of section 19(5) of Pocso Act and section 2 and subsection 14 of Juvenile Justice Act. In section 2 and subsection 14 of Juvenile Justice Act, it is defined as that Pocso victim is also one of the CNCP category, and all CNCP must be produced before CWC within 24 hours. But in Pocso Act, in section 19 and subsection 5, it is specified that the police, whenever satisfy that the victim needs care and protection, then they must produce the child. And in 3 circumstances, generally it is directed to produce the child. One is if the child which is abused in the child care institution or within the family or in the state situation. In that case, the police, the special juvenile police unit must produce the child before the CWC. In these circumstances, the linkage little bit disconnected, and DCPU or the CWC cannot know the status of the Pocso victim, and no clarity on the quantum of payment to the interpreter, translator and support person, and also the special educators. Police very often meet the victim with their robes. The child comes to know that he or she is brought to the police station and interviewed by the police. It is so often we are seeing that the children are invited, called to the police station where her statements are recorded. Next critical gap is in many cases victim comes to court more than once for recording of the statement under section 164 of the CRPC, and
as well as during evidence of the victim.
Yes,
in the court.
Right. More often than not, victims are not examined by prosecution and defense through questionnaire form. In contested cases, witnesses are not cross-examined on the date of their examination in chief.
Courts face difficulties when the audio-video system put in place fails during trial. The child comes to know that sometimes it has come to the court to depose, as he finds lawyers moving around within the court premises. Cases do not end in time. Apart from this, media professionals are not sensitive enough to conceal identities from public disclosures. There is no specific provision for salaries and allowances of the support persons, interpreters, etc. Many times, one-stop centers are not reporting cases of sexual harassment to child welfare committees. Medical tests are being delayed, and sometimes even doctors hesitate to conduct medical examination. In some districts, lady doctors are not available for conducting medical tests of the victims.
There are also some suggestions from the group. One is separate funds must be allotted to the medical units to address the issue of Pocso victim and cater their needs. Second one is special financial aid should be provided to DCPU to meet the for immediate medical treatment of the child, because in the case of interim compensation it is slight bit delayed, but in sometimes we are facing that within 24 hours the child needs some medical attention, and for which some funds to be allotted to district child protection unit, and separate arrangements in child care institution for the pregnant Pocso victims, because some Pocso victims, those who are pregnant, they also restored to child care institutions and generally live with the other children, but such children need special attentions medically and also psychologically also, because they are pregnant. So separate fund provision and arrangements need to be done in all child care institutions. Fourth one, the special juvenile police unit should function outside the premises of the police stations, because we are talking about child friendly procedures, behavior and practices and arrangements also, but in general the ground reality is that the victim is called to the police stations, although the police officers is in the uniform is not in uniform, but in the interacted also in the child premises, child friendly premises, but that child friendly premises or the corner is situated inside the police stations. And fifth one, it is very important, we suggest for child friendly passage instead of child friendly premises, because children court is well decorated, well developed at child friendly court, but in generally the children court is situated inside a court premises, inside the court building, where whenever a child with her parents enter to the court buildings, she has to cross so many ways, through advocates, through police, through clients, and reach to the children's court, which is child friendly. So we demand there should be a child friendly passage instead of child friendly premises.
And separate exclusively space should also be specified within the court premises as waiting space with all refreshment facilities for the victims of Pocso Act as well as the all other vulnerable witnesses.
Yes. Then one suggestion is there for victim compensation. Generally the victim compensation is granted on the basis of injury of the child, basing on FAR reports and medical examination report, but we suggest this should be on the basis of educational and social reintegrational need also. So
the public prosecutors and defense lawyers must put questions to Pocso victims through the court. The special public prosecutor and the defense counsel should refrain themselves from asking the child directly at the trial to demonstrate intimate touching of its own body. The special public prosecutor or the defense counsel shall, while recording the examination in chief, cross-examination or re-examination of the child, communicate the questions to be put to the child to the special court, which shall in turn put those questions to the child.
No, I may please take pause for a moment. I was just listening to you. Whatever you were telling, that suppose at the recording of the statement, this should not be done in police station. Where it should be done, the statute provides, right? That it should be at the residence of the child or the place which he usually resides, at the place of his choice. So all these things are there. Similarly, this passage which you are telling, we have now opened up BWDC center also, and it has been strictly provided that the victim should enter in that particular route. So the accused should not enter. Accused has a different, so 3 rooms have been allotted. One for the room where the presiding officer would record the evidence. The other room is the rest room for the witnesses, The third room is where the evidence is to be recorded. So all arrangements have been made. So, and this question which you said, that is also in the act, that no direct questions should be put. So what I just want to point it out, that since it's a group discussion, you have already, you have to show that this is the procedure and now this is being followed. These are the flaws. We are organizing this seminar to see that what are the flaws in the system, how it can be improved. So you give suggestion in that way, so that we will compile of and appropriately will deal with it in the future. Whatever there in the statute, will just repeat it, that in should be done in the, that is already there in the statute. And if anyone flouts it, suppose the police officer calls a teenager victim to the police station and in uniform records the statement, action will be taken against him because he flouts section 24 of the Pocso Act. So what is there in the statute, don't tell that. You see that what are the flaws there, how it can be improved. The problem which you might be facing as the council or the presiding officer, your reality, ground reality, that should be brought on this discussion, so that how improve the situation can improve. Okay, just I will keep all this in mind. All the group discussion should be to the point, because the time constant is there. That's why I am. Don't tell all those things which are there already in this statute, right? Please proceed.
Yes, my lord. As my lord pointed out, one problem there is that the VWDC room opened in particularly in some districts, and in that particular room, all the vulnerable witnesses of all courts are examined. So time constraint is there felt by the particularly by the Pocso court for examination of the Pocso witnesses. And in some districts there are two courts functioning simultaneously. One is regular Pocso court and another is fast track court. So in fact, on average, 15 to 20 witnesses are coming regularly to Pocso witnesses specifically are coming to depose in the court, and that practical problem is that and VWDC room which is only one room provided for all the courts for examination of the Pocso witnesses, the time constraint is there. That is one difficulty which we are facing during examination of the Pocso victims. And another suggestion which is authorities must take steps to aware grassroots level people to report Pocso cases irrespective of social practices. In some cases, there is seen that many cases remain unreported. Adolescent committees should be trained more vigorously. Support persons should be properly identified and provisions must be made for their salary and allowances. Special units of police should be deployed for investigating Pocso cases. And actually, in fact, though there is a special provision for training of especially the prosecutors and the investigating agency and all other stakeholders, but practically it is not done. In our district, I have written a letter to the SP, and in 1 year, one training program was conducted, and that for all the prosecutors. So regular intervals, in regular intervals as provided in the Pocso Act, the training programs should be arranged. Thank you. Thank you.
Conclude it with time limits. Conclude, Karan, just conclude. Take 2 minutes, but stick to the time limit.
Thank you, all of you, that you are patiently listening to our group two themes. That is friendly, child-friendly week, and this was most of the presentation. Thank you again for your listening.
Okay.
Thank you.
Thank you. Call from the group one that is okay.
Now we have Group 1 ready for the presentation. So I request the presenters of Theme 1 to present on the topic Rehabilitation and Reintegration of Pocso Survivors and Preventive Measures, Practices, Gaps and Opportunities.
यहाँ पर से क्वेश्चन को थोड़ा रिमाइंड करता हूँ जो इन राइटिंग दवा पे
Good afternoon, everybody. Respected honorable judges, members of the Juvenile Justice Committee, all the participants of this meeting. On behalf of Group 1, we are a group of officers who will do the presentation. Let me first introduce myself. I am Arvind Agrawal. I am Director WCD, Women and Child Development Department. Along with me, Shri Sushant Kumar Mishra is the PMJJB Barampur, Dr. Sudarshan Barik, Chairperson CWC Bhadrak, and Ms. Anupama Sahu, UNICEF Consultant of the department. So, the issue that this group discussed was mainly on rehabilitation issues of Pocso survivors and victims, rehabilitation and reintegration of Pocso survivors and preventive measures to identify the practices, gaps and opportunities. So the group discussed vividly on the issues that has been given to the group, mostly the issues the activities being undertaken by the Department of Women and Child Development and the activities done by school and mass education departments. So after the presentation on 4 broad themes some topics were discussed and the PMJJBs, the magistrate of the Pocso courts and also other CWCs and other people gave their inputs to the discussion. So out of after the discussion, the following things came to we concluded with the following presentation. So the key progress till now is, like we have seen that most of the Pocso cases are and the victims are produced before CWC, though it is not 100%, but many cases now more than 3,000 Pocso victims are produced before CWC in last 3 years. And counseling and legal aid is also being provided to the victims. There is a pool of support person, translator and interpreters. They are equally adequately trained and employed, though the numbers are not adequate. Similarly, arrangement system is in place to provide medical treatment, to provide education and vocational training to the victims as and when there is a requirement, and the group was informed about the total achievement over the last few years. And also some success stories were also being shared with the group, how individual cases are being rehabilitated. Again, like the Pocso victims, though the CWCs has to basically take decisions regarding their rehabilitation, either family-based care or to institutions. So it is noticed that many victims are being institutionalized and admitted into the CCIs. Interpreters are also being provided as and when required. Again, like some gaps were identified during this process also. And the group also were informed by the School and Mass Education Department that the victims' education is also being given due priority, and through the field functionaries, the education, continuation of education is being stressed upon. Similarly, different multi-stakeholders awareness campaigns are being organized. These are basically the activities that are being done presently. School and Mass Education Department also has a toll-free number which is available to all children to ensure that no child is subjected to any abuse in the school, be it physical or sexual abuse. Similarly, these informations are being circulated both in Odia and English, and complaint boxes are also being installed in the schools in order to empower girls, and to self-defense training is being given to the girls in schools from class 6 to 12, and this process is continuing since 2014 onwards. In KGBVs, this defense training is given every Saturday and Sunday, and in regular schools it is every Saturday. So in different hostels run by School and Mass Education Department, they have a 3-tier safety protocols. One area which the PPT has not included is the overall management of hostels. So I'll talk about that on at the time of coming to the issues. Similarly, the BOs and gender coordinators, etc., are doing monitoring at different levels. Now, the group identified certain gaps and issues. One thing that before I forget, one issue was discussed regarding monitoring of hostels where children are being kept for education purposes with the consent of their parents. So, it was discussed that these institutions should also be monitored, supervised by some of the government agencies, and presently under the JJ Act, only those institutions which are housing children in need of care and protection are registered under the JJ Act, and accordingly the basic standard of care is being ensured in those institutions. But there are few more hostels are there at many places where girl children are residing for their education and being remained unattended. The quality is not being looked into. So it was decided to recommend to have a mechanism to supervise quality of services in these institutions also. Again, regarding as far as awareness and engagement of community, this was one of the broad topic that was assigned to the group. We have identified that there is a lack of sharing of information, proper information or free exchange of information is not there between various stakeholders. Like the number of Pocso cases over the years is much higher than the children produced before the CWC. So, accordingly, like those who are not produced before CWC remains beyond the ambit of overall safety measures and rehabilitation. Similarly, at the society level, the Pocso victim, it is a stigma for Pocso victims and their families, particularly girl victim. And also, it was felt that for rehabilitation of Pocso victims, much more needs to be done, and there should be a proper monitoring system and proper follow-up for rehabilitation of these Pocso victims also, which is equally applicable for all children in need of care and protection. The second topic was on engagement with adolescent and young people. Here, the gaps that has been identified was lack of knowledge and awareness regarding Pocso laws and provisions, and the offences which are the penal provisions among the adolescents at the community at large. And so as a result, what happens, even children since they are not aware of the legal provisions and penal provisions, they commit certain crimes under the act, like elopement cases. If children are aware of the provisions, some may desist from going into such activities. So it is suggested that there should be a proper awareness on the provisions and including the penal provisions among the community, particularly the adolescents and their families. Skill development centers, like it was also discussed that the adolescent girls, particularly those who are subjected to the victims of sexual abuse or pregnant girls, so there is not a sufficient ecosystem for them to have the training and all. So because the victims face discrimination inside the institutions, so it was suggested to have an ecosystem where the equal treatment can be given to these victims and the pregnant girls also. Similarly, the internet related issues, the digital abuse and other things are also being a cause of concern, where a lot more has to be done. Similarly, the lack of parental control on usage of digital devices and access to internet, so that reflects that the proper supervision of the parents is also being missing, because the parents also needs to be sensitized on the issues. Regarding sexual education and awareness in schools, it is also being seen as a social stigma, and absence of knowledge regarding implications of sexual. Again, this I have already discussed. Now, another issue was on support person services. Would you like to say the PMJJB, Barampur, he will speak on support person services.
So far as the point on support person services, the group discussed the points raised there, and we have concluded some points, what can be done. The suggestions have come from the various stakeholders. These are as follows. Victims are facing isolation from families due to social stigma. Victims are being bribed out for the court settlements. Victim identity is not protected properly, and the entitlement of compensation to the victim not being facilitated on time. These are the areas where support persons services can be taken.
Just to add on support persons also, like in the suggestion it has also been mentioned what needs to be done more on support persons. So at the time we'll discuss.
So far as the rehabilitations, mental health and psychosocial supports are concerned, in case of multiple accused in Pocso cases, victims and family faces inconvenience to go to the multiple courts for submitting evidence at trials. For example, if the victim is a minor, and in a case, suppose 2-3 accused persons are there, and one is the juvenile, or and others are the adults, then the same victim comes to the juvenile justice board for trial inquiry, and the same victim again goes to the Pocso courts. That victim is again victimized through the systems. So that aspect has been identified by the groups. Then next is the standards of counseling is not maintained. So there are counselors, but that counseling is not up to the standards what the group has discussed. Though there should be a professional counseling, panel of counselors should be maintained who can counsel the victims. The lack of data regarding the counseling supports, we have discussed in details regarding the lack of coordination between the different stakeholders in accessing the data. So far as we have discussed that in the districts, the district child protection unit is the nodal agency who is implementing the various aspects of the Juvenile Justice Act and the Pocso Acts. So far as the Pocso Act is concerned and Juvenile Justice Act is concerned, the district child protection unit maintains the panel of counselors, support persons, the psychiatric and other persons who can support the victims. At a time when the Juvenile Justice Board and the Pocso courts deals with the matter, they are lacking with the data. So that is why we have suggested that there should be dedicated portals of the District Child Protection Unit containing all the data and information, so that data can be received from the dedicated portals. Next, interim shelters and considerations. CWCs in certain cases do not grant order for Pocso victims to reunite with the families regardless of their consent due to certain information discovered during the course of investigation which is not in the best interest of the child victim. Adequate number of observation homes are not present for the time beings, and in the discussion it was told that a number of observation homes are being under constructions and they will be functional near shortly, and a lack of knowledge about the existence of child care institutions. So many of times we are facing that the location of the child care institutions and that was also deliberated, and it was discussed that the database should be prepared and the same should be shared between the various stakeholders who are dealing with the Pocso victims. Next point is the low accessibility and quality of life in observation homes. We have, after a lot of deliberations and consultations, next.
So, now the group, after identification of the gaps, has also deliberated on the possible solutions that different stakeholders can adopt. One is like, in order to create awareness among the community at large, and to ensure that last mile to the last person is also being contacted and made aware about the provisions and the consequences and different aspects of the sexual abuse. It was suggested to involve Gram Sabha, SHG groups and other the communities to discuss and dwell upon different social issues, not only Pocso related things but child marriages, violence against women, dowry, or other related social concerns which we are facing. So actively involve Gram Sabha, Palli Sabha, etc. And now since due to the digital abuse, it was like there are various safety protocols one has to follow. The government has also the Home Department has issued certain instructions also on measures to be adopted to avoid any digital abuse. So those informations need to reach to each and every individual. So they need to be made aware either in person or through such Gram Sabhas and all, or through Anganwadi centers and Asha workers. That platform we can use to disseminate this information. Again, like in order to make the provisions, the effective implementation of the provisions of the Act and to prevent any abuse against the sexual abuse against the child, it was recommended that all institutions like be it school, colleges, higher institutions, they should actively discuss on the provisions of the Act and also different not only of Pocso but other similar acts, and there should be like there are various institutions which look after such cases, like the district level child protection committee, block level child protection committee, village level child protection committee and the GP level child protection committees. Similarly, various IEC activities are conducted by the DLSA, by our departments and various other departments, Panchayati Raj, etc. So it was suggested to have a fixed agenda to discuss on such issues in all such platforms, and to we have to go on a mission mode to tackle these issues, and simply since we have to involve each and every stakeholder into this process to reach out to the last person. And next is like in order to have effective communication and free flow of, and exchange of information among different stakeholders, it was suggested to have develop a mechanism where the informations, various informations is made available to all stakeholders and also to the public. So the informations can like the panel list of the stakeholders, the counselors, interpreters, etc., the places of the CCIs, such basic informations can be made available on the district website. so that the information is available to all. Similarly, registry of such information is also being suggested to prepare for assistance of all the stakeholders. During the inaugural session itself, the consensual relationship was also being discussed, and whether that should be a criminal activity or not was also being discussed. And since every consensual relationship may not end in a positive note, so instead of making it completely decriminalized, rather effective. So we have to have a system where such type of crime should be dealt separately instead of dealing it with all other criminal activities. And schools and teachers and other stakeholders should be effectively engaged for creation of awareness. Now, for adolescent and young people, it was recommended to engage with them effectively and to include these issues in the school curriculum, which is already being done, but in a better manner. Similarly, the provision of childcare facility in the courts and awareness, particularly the interim compensation. The issue of interim compensation was also discussed, and it is felt that in case of compromises, generally the interim compensation are not being given, whereas due to want of money only, in many cases it is noticed that the compromises are being done. So if the compensation issues are being dealt liberally, then the chances of compromise due to financial reasons will be reduced. So it was suggested to give compensations in a liberal manner. And Advika platform should be used for extensively for dissemination of information. Again, for support persons, it was in order to have a robust system of providing support persons, the identification of support persons, giving them their capacity building and their sensitization are also being stressed. More number of people can be engaged, like the CCI staff, the paralegal volunteers, etc. should be involved into engaged as support persons, and some financial remuneration for to meet their regular expenses. Similarly, for rehabilitation of mental health and psychosocial supports, certain the group also recommended to strengthen the system of mental health support and counseling by engaging trained personnel, may not be a professional, but taking due training. So to develop a system of providing trainings and so interim shelters, again it should be decided in a case-to-case basis, where the principle of decision should be taken in the best interest of the child. And these are the best practices. It was basically Advika scheme. We proposed that Advika scheme should be highlighted as a best practice of the state in the national level. So these are, since time is short, I thought I'll speak up more on Advika, but since time is short, I'm just skipping it.
Thank you. You see, whatever each of the groups have found out during the theme discussions, and whatever suggestions they are giving us, please give it in writing so that it will be compiled off, and we'll utilize it in a better manner, and we'll ask the appropriate agencies to look into it. That's
yes, sir.
Right. Each group, please print it out and hand it over to the director or the of the Odisha Judicial Academy, director in charge, so that. All right. Thank you.
Thank you, sir.
Thank you. It was a nice presentation, really. But one thing I just want to see that whatever just it has been told that we want more and more and more in this line, but we should also think that what are the infrastructures, what are the facilities which are available with us, and how we can best utilize it. That is the most important things. Because when these BWDC centers opened in all these 30 districts, huge amount of money was spent. And I am the chairman, of course. We called for the report that how you are utilizing the BWDC center. The report was so poor that even though hundreds and hundreds of Pocso Act cases are there in, but those centers were not utilized. The nil reports are coming about the. So then we talked with the London district judge and the Pocso Act judges time to time, and now it has of course improved. Now it has come to every month there used to be 1500, around 1500 cases in which the recordings are being done in the BWTC center. So we are also to look into it, that when everything is available with us, how we can best utilize it. It's all right that these are the flaws are there. We want all these things for further development, but simultaneously we should know that how to it can be utilized in the best manner. Yes, please continue.
My Lord. Before proceeding to the next presentation, I would request our audience who wish to put any questions to the presenters, they may do so by writing their name, designation, the specific question and the theme on a piece of paper and submit the same to our Additional Director, Odisha Judicial Academy. Now I request the presenters of Group C to kindly present on the topic Investigation of Cases under Pocso, Role of Police, Medical Officer, Special Public Prosecutors, Probation Officer and Support Person.
Introduce themselves, then proceed. Yes.
Respected Honorable Judges on the dais, dignitaries and all the participants, we are giving presentation on behalf of Group 3. I am Bibhu Prasad Panda, Pocso Judge, Special Judge Pocso, Noyagad, and Madam.
I am Dr. Abarnita Sethi, Assistant Professor, Department of FMT, MKCG Medical College, Barham.
Tell the theme name first, then you proceed.
Yes,
your theme.
Yes, madam. The topic of discussion of today is the effective implementation of Pocso Act 2012, and our theme is investigation of cases under Pocso, role of police, medical officer, special public prosecutors, probation officer and support person.
Right.
During the period of discussion, we have ADG Home Department, the Director Health Service and other resource persons with us, and participants, judges, Pocso judges were there, the special PPs were there, and also officers from different departments, stakeholders were there. And after a long discussion, we reached at this presentation, and I will be presenting one by one. Actually, the subject, the theme is investigation of cases. It is true that Pocso cases are being investigated, charge sheets are being filed, submitted, and trials are being concluded with whatever may be the result. But this sector, this aspect needs lots of development. But before I go for this part needs development, we will give what are the key progresses in the in between, I mean in recent period. The major development we have is the BWDC centers in Orissa. As Honorable my Lord was speaking, we have 30 BWDC centers in all over Odisha, in all the district headquarters. In fact, earlier what we are facing problem was the victim was sitting along with the accused or along with other persons in the same courtroom or in the same waiting room, and she was giving her deposition or she was reluctant to give her deposition. But by way of setting up the VWDC centers, now it is very easy for the prosecution side to get the victim be seated in separate room and getting your deposition recorded, and we are also facing no problem in dealing with the victims and taking their deposition. That is the most important progress in recent development and by our honorable court. So also special Pocso courts have been established in all the districts in all over Orissa. In addition to that, track courts have also been established for quick disposal of cases. There are establishment of crime against women and children wing under the crime branch Bhubaneswar, who is monitoring the crimes against women and Pocso cases specifically. There are one-stop centers in all the districts. As far as medical officers are concerned, SOPs have been circulated among the medical officers with guidelines and protocols for while examining the victims and giving their reports. Handbooks have been developed and given to the doctors and nurses. Also, for development of the psychology and the mental health units have been developed in all the headquarter hospital in Orissa. But still there are many gaps and challenges. Some are like those. One is timely investigation and filing of charge sheet. During discussion, we all judges, Pocso judges, gave a statement and discussed that the charge sheets are not being filed timely. The courts are facing problem. As per section 73(2), the charge sheets in Pocso cases have to file within 60 days. What the IOs are doing to comply the provision, they are submitting preliminary charge sheet, keeping a lot for the final charge sheet. So timely investigation and filing of charge sheet is mostly required for this effective implementation of Pocso Act. Otherwise, the evidence of the victim cannot be taken up within 1 month and the case cannot be concluded within 1 year. Then some medical officers raised the concern that safe kits are not available for collection of samples and DNA profiling. So safe kits should be available, because it is available, what I am given the impression, it is available at SFSL level. I request Madam Dr. Sethi to say about something.
We are living in a time where DNA profiling is very important, and it is a very important evidence for this, even for proving a case, and also for the pregnancy and making the paternity dispute. And so this safe kit it should be provided in all hospital, and that is also for this to remove the contamination from and to prevent the decomposition of the sample. It is very mandatory. And also we are having, the government is doing regular time to time this training for, and SOP or the guidelines have been provided, but the basic is to do the training process of all these SOP and protocols, so that all the it can reach to all the doctors of the nook and corner of this state. So this is very mandatory. So I give it to next to sir.
Even the courts are facing problem on medical reports because the samples are not collected properly or timely, or even the reports are not coming timely. So, which one? Sample collection. Okay. Another is abandonment of children by caregivers. In some cases, the parents are not taking care of the children of the victim, after their rescue or whatever may be after the incident. So the children are not being properly cared, for which they are not being able to give their evidences in court, and even if their well-being is not being taken care of after the incident. There are lack of convergence among the different stakeholders. Different stakeholder means IOD, medical officer, CWC. There are lack of coordination. Everybody is doing their own job, but there is no proper coordination. The madam will say about lack of information on medical boards.
Sir, as discussed in the department and also by the information given by the director, we know that there is a state medical board for this for medical termination of pregnancy. If it is usually it was for up to 20 weeks, it was it was confirmed by one doctor, and after 20 to 24 weeks it can be done by 2 doctors consent. But gradually, if it is more than that, and in Pocso cases, it is according to the new amendment, it is to be done by a medical board. But till now we didn't have any. Each and every doctor didn't knew how it will be the consent can be taken, and because this with this going time, the duration of pregnancy increases. So this is a real challenge that as early as possible this medical board consent can be taken. And he has also informed us that some letter has been made to again form this board at different district level, so that it will be easy for confirming these MTPs, so that the child will be saved from disaster which happens and health issues which happens if it is the pregnancy is terminated at a later age. So this is the prime concern. And again also there is a problem that how if once she goes to home then she become pregnant, so how she will be contacted to CWC, or they will come directly to the hospital, so who will track? There should be a support system.
Another important challenge is that lack of appointment of support persons affecting child's well-being. Actually, when the child is brought to the court, she is produced before the CWC. The CWC is only concerned only for keeping the child if the parents are not willing to keep her at that time. But no steps are taken after that. If the child is returned to the parents, whether the child is pursuing her education or not, whether the child is being protected from the, whatever trauma is there, whether proper steps are being taken or not, nobody is taking care. So, the support person should be there to take the child for the well-being of the child right from the beginning till the end. We discuss some way forward. What we found is the support person is to be appointed from the date of recording of the statement, prior to the date of recording of statement by the police. 161 statement, before 161 statement is recorded, the support person should be appointed, and he or she should be continued till the end, because that support person will remain with the child. He would or she would give counseling to the child in the 161 statement, 164 statement, during the evidence in the court till the end of the trial. So the support persons need to be there. Another important factor is that the IOs are not consulting with the special PPs during investigation on different aspects. So the special PPs should be contacted or coordinated by the IOs either directly or through the court during investigation. A medical social work department to be placed in government and private hospital. Then, as I have stated earlier, safe kits to be available to all public health departments. Yes, one important aspect we discussed is that in a district, one Pocso court is there. There are 15, 20, 25, 30 police stations are there, different IOs are there. The Pocso court has to coordinate or contact, the Pocso court has to contact the IOs on different requirement. One nodal officer should be placed in each district who will coordinate with all the Pocso cases. Also in the JJB cases, who will coordinate in all JJB cases and Pocso cases during trial and during investigation and during trial also. Then the pool of stakeholders to be available, the names and address of the stakeholders of the district should be available at courts, DCPUs, hospitals and police stations. The names and address and their phone numbers should be detail given in a board at all the places. Then to appointment for the support persons for the disabled children, there should be identified support person in each district, because sometimes it happens when a disabled victim comes, the IO finds out where is the expert to bring so that his words can be translated or like that. So a identified support person should be there. Of course, now we have Bharosa centers, as the additional DGP stated, the Bharosa center in Andhra Pradesh, where one center is there where the court, the IO, the support person, the everything is available. If that is possible, then it is also help to for the effective implementation of the act. There are some pictures of the Bharosa center. Thank you.
Thank you.
Thank you, sir and ma'am. I request each group on the 4 themes to give in writing what are the practices that are followed on the field and the practical problems and the lacunas which are being faced by them and how it is to be improved. I also invite questions from the audience in writing. Now proceeding to the last theme, that is theme 4, I request the presenters of group D to kindly present on the topic building capacity of functionaries under Pocso Act and the role of state-run training institutions. I request the presenters to kindly come to the stage.
नहीं जो गोटे जी आंसर हम गोटे जी क्वेश्चन पुट कर नहीं जान हाँ नहीं से आगे क्वेश्चन आंसर हम तापर स्पीकर माने पुणी क्वेश्चन ओपन हो तीनटा रोड तीनटा खाद्य माइक Suppose data
Honorable Chairman and judges of Juvenile Justice Committee, Honorable judges of our own High Court, senior officers, participants of state government, including Srimati Saini S, IG Training Center, Biju Patnaik Police State Academy, Additional Director of Odisha Judicial Academy, officers of Registry Odisha High Court, officers of Odisha State Legal Services Authority, and last but not the least, the main representatives of the UNICEF and the National School of Law University. I, Shri Vishwaranjan Behera, Additional District Judge, has been posted as Presiding Officer of Pocso Court at Sambalpur. Shri Lalitendra Devta is with me. He is a student of LLM. I am privileged to have the opportunity to put forth the presentation of our group B on theme that is for capacity building of functionaries under Pocso Act and the role of state-run training institutions. I am to present the overall discussions made by our groups, which comprises 7 presiding officers of Pocso courts, 3 principal magistrates of JJBs, representative of special juvenile police units, DCPOs, WCD, SIRD and Panchayat Raj departments, and the faculty of National Law University, Odisha. We discussed the topic thread and bare, which I am putting forth under the following sub-headlines. The first subheading is the role of state-run training institutions for different stakeholders. And the second one is that the availability of training materials and pool of resource persons and information, education and communication materials. The third one is that the role of NCPCR and SCPCR in monitoring implication of Pocso Act. And the fourth one is the good practices, and the last one is the progress and challenges in these areas. So, in respect to under first heading, the role of the state level training institutions, we have Odisha Judicial Academy, and in every year there is a plan, calendar plan to provide training programs to Pocso judges, principal magistrate of JJBs, public prosecutors, and the training programs are conducted frequently during course of a calendar year. Sensitization of taking evidence of victim and recording of the statement. This is the most important area at the time of dealing the Pocso Act by any criminal court, by a trial court. So we must be very careful at the time of recording of the statements, and what need of things we have to judge and what sort of things we need. These kind of sensitization programs have been undertaken by Odisha State Judicial Academy, and how the trial has to be made in camera. And now recently the VWDC scheme has been launched, in which the victims are being examined at VWDC center in a separate room where the child-friendly atmospheres are there. So several steps are taken from day to day for through which the victims are feeling more graceful, feeling more comfortable. There is also a police academy, namely Biju Patnaik State Police Academy at Bhubaneswar. They are also providing training programs to their police officers. They are providing the basic courses of newly recruits. Usually, the rank of when the investigating powers has been conferred upon the assistant sub-inspector. So thereafter, when they are newly recruited, their basic training programs has been provided to them. Are provided to them how to investigate into the Pocso cases. The persons, the police officers who on their promotion into the next cadre, they are also undergoing the training programs. And recently, they have launched that the resource persons have been sent to different areas where the training programs have been conducted by the resources persons in different districts. Women and Child Development Department, they are also conducting training programs for budgetary provisions for imparting training programs for all stakeholders. Sensitization and capacity building of DCPOs are also conducted through OCCPS, and availability of training materials and pool of resource persons. The training materials are available in local languages, and state level resource pool of trainers includes experienced judicial officers, experienced police officers, faculties of law university. They are inviting many number of judicial officers and the officers who are also retired, who have enough experience under their belt regarding investigation of different sexual violence cases. They are also invited to provide to give training programs to the newly recruited officers. Secondly, the information, education and communication materials are also circulated for raising awareness at different levels. The printed materials are also circulated by the academy to different police headquarters for the investigating officers, so that awareness can be developed between them, how to conduct a case, how to examine a victim, how a victim can be medically examined without any duress, without any fear. Then role of Odisha State Commission for Protection of Child Rights, what they are doing. SCPCR take so much cognizance of the news published relating to the sexual offences that it received as an information. Suppose an article has come on a newspaper, suppose a news is circulating on television or different websites, immediately SCPCR takes cognizance and two effective steps for rescue of the victim and other procedures. It monitors violation of child rights in schools, CCIs and any other child care related institutions. Frequent monitoring, frequent visiting of these institutions are being carried out by SCPCR. Now, what are the challenges before us? The alarming rise in the number of reported child rape incidents, it was held by the Honorable Supreme Court that 96% of child do not get support person. The support person means they must be present, they must give psychological support, and they must be present throughout the, when actually the victim needs the care and attention. The Panchayat Raj institutions also plays a vital role. They need to be sensitized by the stakeholders regarding Pocso and JJ Act. I mean to say that the Panchayat Raj system covers under 3 acts, the Gram Panchayat Act, Panchayat Samiti Act and Jilla Parishad Act. Maximum people are living under the area where the Panchayat Raj system is inactive. That means in the in village areas where the Panchayat Raj PRI members are working, the influence of PRI members over the peoples are highly felt. Normally, they do not listen to either the word of the public officers, but they usually care and they give the care and attention to the PRI members. Therefore, they need to be sensitized. SIRD curriculum to include the topics on sexual violences against the children. Actually, the children must be aware about the aim and objectives of the Pocso Act. The only awareness can defeat the process. The periodical meeting of SJPU and at the police stations need to be done. That has not been carried out usually. Every police officer should be trained on the nuance of the act and the sensitizations regarding child issues and offences. Every second officer should be deemed to be a child welfare officer. Usually, these, though there are the systems that these every police officer should be trained, but usually we see when the actually in fields it could not be carried out. During the group discussions, we have some suggestions which, we have discussed about certain good practices. In Odisha, all the Pocso courts and the juvenile justice boards are examining the victim during trial under the VWDC scheme. Recently, for the examination of the victims, Honorable High Court of Orissa has launched the scheme, the Vulnerable Witnesses Disposition Center. Now, it is to the court. Usually, the child, every victim child are the vulnerable witnesses. Thereafter, the authority also lies at the hand of the court that to declare whether other witnesses are vulnerable or not. If court find that they are vulnerable, that they need to be examined in the vulnerable centers. Odisha has currently set up 44 number of trial courts, including fast track court under Pocso to deal with the Pocso cases. Usually, under section, in view of the provisions under children courts have already been set up. Thereafter, in Pocso Act under section 18, the children courts were authorized to deal with the Pocso cases. Subsequently, by the recommendation of the Honorable Apex Court, the fast track courts have been established in different districts, have been set up and to deal with the Pocso cases. Next, the child-friendly panchayat initiatives are being conducted. The Rural Development Department and Health Department under Gramma Kalyan Samiti for sensitization of the programs. The Panchayat Raj the lady member who has attended from the Panchayat Raj Department has elaborately stated that the 2 number of panchayats have been undertaken for implementation of for giving awareness regarding the Pocso Act. So this has been conducted by the Rural Development Department and Health Department simultaneously under Gramya Kalyana Samiti Yojana. Training programs are conducted by the Judicial Academy for proper implementation under VWDC scheme. This is also one kind of achievement. Then during discussions we have also some suggestions what we have to do in future, what we have a plan, but what should be done to create awareness among the stakeholders through training program. First one is the functioning of one-stop center for medical examination and recording of the statement of the victim. In fact, at the time of investigation, the police first rescued the victim girl. Thereafter, he took her to the medical for her examination. Thereafter, the police produced the lady before the magistrate, where the recording of the evidence, her evidence has been conducted. So all those processes are taken in different setups. Thereafter, the suggestion has been made. We suggest that it should be done under one roof, so that it can be effectively done. 2 types of training programs also required. One is community-based training program, including 8 Anganwadi workers, ASAs, ANMs, and PRI members, because they are working within the community. If we will aware them, we make aware them, then definitely our aim and objectives will be fulfilled. Then, to strengthen the institutional training along with SOPs and guidelines for different stakeholders, one booklet must be published, and we have different stakeholders under the Pocso Act. Some stakeholders do not know their rights and duties. To make aware them, a leaflet or booklet must be published, where the rights and duties of these stakeholders must be written separately. Starting of the community awareness from the school level, utilizing teachers via multimedia approach such as animated clips on YouTube, television, and social media apps. Because the children are much more interested to watch these kind of clips. If you will provide them booklets or some written documents, they will not go by that. If animated clip will be provided through different social media or television, then definitely they will be attracted and they will listen it carefully and they will be aware of that. Development of training materials and IEC materials in local dialects. We have different, in our Odisha, we are living in a society where the different languages are, the people speaks different languages, understand different languages. So, like Santali, Kui, Kosli, so we must have published the different materials on these languages. Vibhu sir already told that the record of statements of the victim by the police magistrate and medical examination of a victim under one roof like Telangana Bharosa Center. We have heard that in Telangana state there is a scheme, there is a center near Bharosa where the examination of the victim, recording of the statement of the victim are undertaken under one roof. The support personnel counselors be engaged to handhold the child victim and family members through the entire process starting from the investigation till the trial, conclusion of the trial. because we see in normal occasions the victim gets hopeless. After the commission of the crime, she is in she and her family members are confused where to go, what to do. So in order to avoid such kind of crisis, we need different support persons who will support the family members and the victim from the stage of the investigation till the conclusion of the trial. Helpline numbers will be opened for the investigating officer for their clarification about the rules and regulations relating to the Pocso cases. Normally we see the police personnel or the investigating officers are investigating into the Pocso cases, but sometimes they are facing problems. They do not know what the circulars, regulations has been enacted, what are the new circulars have been launched. So in order to in order to meet their difficulties, so one helpline center may be opened at the Bijpatna State Police Academy, so that at the time of need, they can ask the questions and they can get answers, so that the investigation of Pocso cases can be effectively done. Another suggestion has been made in any Pocso cases, victims has been examined number of times by the police officers. The victim comes to the medicals, the victim comes again to the court of the magistrate where her statements are to be recorded. So again during course of the trial, after 2 years or 3 years or the same year, again victim comes and give deposition before the court. So it creates an offensive situation to the victim. So in cases, it is our suggestion that a suggestion must be sent to the law commission that make the statement of the victim under to the statement recorded under section 164 of CRPC of the victim may be treated as substantive evidence, so that the victim need not to again examine in chief, only she is subject to the cross examination. So it is suggestion. I do not know how it will be worked out or not. Another thing is, the most important thing is that we are facing at the time at our district levels, that suppose I am posted as presiding officer of Pocso court, but I do not know who is posted as DCPU or who is a child welfare officer. Many times we need their support, but we are not getting that. So in order to avoid all these problems, so we need a monthly coordination meeting at the district level between all stakeholders under Pocso Act need to be done, so that we may interact with each other. Suppose I face some problems, the interaction can only the way to rule out all these problems. So this is my suggestion, and I believe that the smallest good deed is better than the grandest good intention. Hence my group humbly submits that even if one of the suggestions made by us by brainstorming today helps to improve the training of the stakeholders, and thereby the justice delivery system will make all our efforts of today consultation worthwhile and fruitful. Thank you.
Thank you. Please give it in writing. All the groups are requested. Please give it in writing, whatever you have stated, suggestions which you are giving, give it in writing to the director, so that we will compile it up. Thank you very much.
Thank you, sir. With due permission of the Honorable Chair, may I now declare the floor open for question and answer and group discussion.
No, actually a request was made that any questions is to be put that should be in writing and names and on particular theme on which you are supposed to ask the question, that should be done, but we find that only one gentleman has given it in writing. So I am just inviting him to put the question so that it relates to theme 3. That means investigation of cases under Pocso, role of police, medical officer, special public prosecutors, probation officer and support person. And the gentleman is Dr. Jay Prakash Parida, Senior Resident, Department of Forensic Medicine, SC Medical College Hospital, Cuttack. Please hand over the mic to him so that he will put the questions, and the I would ask the participants or the moderator or whosoever may be from group that theme 3, if they can answer, they can answer it. Please proceed.
Good afternoon, everyone. Sir, in the morning session, we already discussed about in our group, we discussed about the capacity building. In the session, we also discussed about the lacunas during the investigations. As a medical officer and a forensic expert, I feel that during accused examination or survivor examination, when I have put the question that when a teenage pregnant woman, married pregnant woman from a different community, minor community, comes to for antenatal checkup, regular pregnancy checkup, and she is 15 or 16, what should be our role to report the case to the police or not, as they don't follow the Hindu Marriage Act. When we ask them, why did you marry in such low age, and they say directly that we don't follow Hindu Marriage Act. So in our custom, we marry in such ages. So what should be our role in reporting the cases to police? Should we report or not?
Okay, anybody from that group, particular group 3, if you can answer this question, please answer. You see, normally there are two provisions so far as medical examination is concerned of a child. One provision is there in Pocso Act, the other provision is there in the CRPC. So far as the Pocso Act provision is there, that is in section 27 of the Pocso Act, that deals with medical examination of a child. So suppose a child comes to you, child, you know the definition who is child. So, and you found that an offense has been committed, or it's a medico-legal case, right? So you need not wait for the registration of the FIR. Okay, once it comes to your knowledge, you can intimate to the concerned police station, right? So that you need not wait that let the FIR first be registered, then I will. Similarly, suppose a case of injury comes to you. You do not, first you treat the patient, whether the FIR has been registered or that. Then the other procedure has been followed, that has been laid down in section 27, that if it is to be done, in what way it is to be done. That has been prescribed in 164A, that ordinarily it is to be in the government hospital, and if it is not available, then how it is to be done. Then it is said that it is to be, if it is a girl child, it is to be done by a woman doctor, right? Then it should be conducted in presence of the parents of the child and any other person in whom the child reposes trust or confidence, that is there. And it further says that if the parent of the child or the other person that is not available, then what is to be done, that it is to be, medical examination is to be conducted in presence of a woman nominated by the head of the medical. So these are the in normal case. But what you are now telling one thing, that she is a married lady, as I found from your question, she is a married lady and she has become pregnant, right? And so far as Hindu Marriage Act is concerned, a particular age has been prescribed for the marriage. So that is not there in that custom, and there was an early marriage. So whether you are to report or not, is it your question?
Yes, my lord.
Okay. Can anybody now please?
Sir, legally, as this is a minority, as I understood from gentleman, with this regard, sir, she can report this officially. This has to be reported before authority. And with regards to checkup and the facilities, yes, as per the Minority Act, it approves because the lady is 15 plus. In some minority act, it allows that they can go for, in our context.
Is anybody having any idea on the Muslim law that what is the, is there any age limit for the marriage? Anybody has any idea? Like in our Hindu marriage, there is the marriage age has been prescribed. So, I do not know that. Sir, please, ma'am, please.
The age for marriage is not in the Hindu Marriage Act, but under the Child Marriage Restraint Act.
Child marriage, no.
So that is applicable for everyone. And I was just checking this out. Recently, the Supreme Court has said that it's a serious omission on part of anybody obligated to report offences under Pocso, which would answer your question simply saying, yes, you have to report. And even in the Hindu marriage, because when you look at the exception to marital rape in Indian Penal Code, 15 to 18 years of married women, if the man has sex with them, this is exempt, but that is not what the Supreme Court has said now. They are saying even in the Hindu marriage, having sex with a wife below the age of 18 is a Pocso offense. So the answer is clear, but that has led to a lot of heartburn and that's a very major critique. But as far as the simple answer is concerned, yes, you are obligated to report. It has led to judges themselves saying, because it doesn't make sense in the Indian in our scenario where we have a lot of child marriages happening, lot of children becoming mothers in the marriages, and then to say we will penalize the husband now, he goes for minimum 7 years no, in case of children it's 10 years. So minimum 10 years husband will go. So the judges are coming with answers saying, giving reasoning like this, okay, under the Muslim Marriage Act, it is permissible to marry at the age of puberty, which 15 and it's a valid marriage, but that's actually not in accordance with the understanding of sex within marriage is also prohibited by Pocso.
Thank you, ma'am.
I'll add to what Professor Kumari said. All these acts are penal provisions. It applies to all citizens equally. You cannot take the plea that I belong to this community, that religion. All these are citizens of India. So all these religions, they are bound by these statutes. So you cannot take the plea of your caste, creed, tribe, or community, whatever it is. It applies to all equally. Once, it was said, Child Marriage Restraint Act, or be it under the Indian Penal Code or the Pocso Act, these are all penal provisions. It applies to all citizens equally. So you are a duty bound. The moment you come to know that a minor, some offence has been committed on a minor, you are duty bound to report it immediately. Sir, and the recent judgment of Supreme Court by Justice Chandrachud, the present Chief Justice of India, same line. Even if minor with consent, then also offence is constituted under the Pocso Act.
Sir, in our house, we are discussing about informed refusal. Is it allowed or not? I mean,
no, you have to inform. The moment you come to know about the offence, you are duty bound to inform it to the police immediately.
Okay, we are taking up the next question. The next question relates to Group 4, and the question is has been put by Manas Kumar Mishra, is the fast track Pocso High Court judge from Keonjhar district. Please hand over the mic to him and please put your questions.
My question is to Group 4. Towards the last part of the discussion, the presenter had made an opinion that let the Law Commission be informed to treat the 164 statement of the victim girl as a substantive evidence. My question is whether it violates the mandatory statute of the Criminal Procedure Code, that is, no evidence shall be recorded in the absence of the accused, number one. Number two, if it is recorded, then whether it is going to affect the natural justice of the accused, because in his absence, the evidence, it will be treated as an evidence. Number three, he did not get any scope of making the cross-examination as a result of which the 164 statement may be vitiated and that entire trial may be vitiated.
Okay, you see, the procedure which we follow is that the statements are recorded during course of investigation, maybe 161 or 164, and after the charge is framed, obviously summons are issued, victims comes, and her evidence is recorded in chief, and opportunity is given to the accused to cross-examine. That is the procedure we follow. And law is well settled also that the statement recorded under section 161 CRPC and 164 CRPC are not substantive evidence, right? And even if, let us say, somebody says in that I have stated like this, that means he admits that I have stated like this, but in court she does not state. See, in court she does not state anything. When on being confronted by the public prosecutor that you have stated like this before the IO, you have stated like this before the magistrate, he says that yes, I have stated like that. That will also not make that statement a substantive evidence, right? That is the decision of the 3-judge bench of the Honorable Supreme Court, 61 Supreme Court. So the evidence has to be given in court. You are right that in presence of the accused it is to be recorded, because the defense counsel or the accused has a right to know that how the victim deposes. They may notice the court is also there to the demeanor of the victim while giving the evidence. That is to be noticed, and that is also to be recorded. But you are not correct that in no case the evidence of the victim will be recorded in absence of the accused. There is a procedure section, a particular section, I think it is section 290 something, right, 299, you are right. So that it says that in what case the evidence can be recorded in absence of the accused. So at present, as we stand now, that evidence has to be recorded. What he has given the suggestion that whether we will accept that, suppose in one case it has been recorded by the magistrate, right? And it is that very statement under 164, whether it is to be treated as the evidence of PW1, the victim. It will not be recorded. What he is saying that it will cut short the victims again deposing, narrating the same thing again and again. That trauma, mental trauma aspect is there. But the problem is that in many cases we find also that suppose there are material to show that the victim has been tutored, right? And that is how she comes to the court and give her 164 statement. Okay. So she may change her version during trial. So you should not say that whatever she has stated before the 164 statement in the before the magistrate, that is the gospel truth. Okay. So that is to be tested by the because ultimately on the basis of statement a person's life and death is there on the other side. That is to be seen. So now as far as we are now, the position is that very clear. Victim has to come to the court, give her examination in chief, as well as she has to face the cross-examination. At present there is no question of, unless of course the law changes, matter is different. Otherwise that should be the procedure. And there is a also I think that should be also the procedure, but it should not be treated, in my, if my personal opinion is taken, it should not be treated as substantive evidence, the 164 statement. That is my personal view. Yes, anybody can say, Mr. Devo.
What is that statement? That statement under section 164 CRPC is a statement in course of investigation. So it can't under any circumstance be used as statement before the court during trial. So for that purpose, we require that statement. It is, one is 161, which is recorded by the police, one is 164, which is recorded by the magistrate. But those are all statements in course of investigation.
Thank you. Now the next question has come. It is really heartening that you are now coming to participate in this question. Janaki Biswal, Special Judge Pocso Jaspur, she has put the question. Please hand over the mic to her. Yes, ma'am.
My lord, I have a case where the victim, who is a victim in a Pocso case, she was aged about 16 years, and out of her relation with the accused, she got pregnant. Interestingly enough, during interestingly enough, during investigation.
Sorry, sir. Don't please don't ask any question on the pending cases, please.
Not regarding pregnancy. Sir, actually, if the victim who got pregnant,
you put it that way. You put it that way.
Interestingly, the police investigation report and the medical report does not reveal her pregnancy. The thing is that when the time was fixed to conduct her medical examination of pregnancy test, one date was fixed, but she could not be produced before the medical authorities, as the accused again took her away from her family members. So during the process, her pregnancy test could not be done. But now the victim gave birth to a child, and none of the police papers and the medical report, nothing in the case record reveal about her pregnancy. She is now saying that I am pregnant. The child is with her. I got pregnant and the child is with her. So at this stage of the trial, what is the process available before the court to get her pregnancy, to get the DNA test of the child done? Either we can do, as we are in the trial stage, whether we can proceed with the IO, involving the IO for the DNA test, or we can directly proceed with the doctor and SFSL for the DNA test of the child.
Yes, that question relates to anybody can answer it if you are aware about the same. Please hand over the mic. Yes, anybody can. The solution no doubt remains, madam, that is the DNA test is the only way out to know the paternity aspect, right? So suppose at a particular point of time that was not done. Subsequently, it came to the knowledge of the court, and that was also on the basis of the statement of the victim. Then if there is no problem so far as consent is concerned, of the victim is concerned, then DNA test can be done, and of the victim, child, all these things can be done, and by the appropriate agency, so samples can be collected, that can be done. There is no problem. That if it has not been done in the investigation stage, that cannot be done at the time of stage of trial. There is no such thing is there. That can be done, but it depends upon, first of all, whether consent is there or not. You cannot just otherwise the evidence of the victim has to be assessed, because it depends upon as to who is the culprit. If he says that this man has made her pregnant, and how far her evidence is believable, trustworthy, reliable, that is to be taken into account. If the DNA test report is not there, okay, so that aspect is to be taken into account. Yes, yes.
Sir, we can do the process through the
You pass the judicial order, you can call for the government medical officer, and samples will be collected. Okay, that is to be, but again the route goes to the giving consent of that. That is right. So now the next question, then we will come to the next, that is okay, one question has come from Neha Naidu, UNICEF. Ma'am, please hand over the mic.
Sir, actually it is a suggestion. This came up in our group and also in my interaction with participants of other group. district level coordination and convergence between various stakeholders who are dealing with Pocso is something which all of them feel that they are doing their role, but that convergence meeting where they are sitting together and addressing the issues related to Pocso is not happening at the district level. So, and in one more thing we noticed, sir, in the senior officers meeting, a representation from WCD is not there. Also at the DALSA meeting, representation of WCD is like SP, collector, chief medical officer, district judge. So DCPO plays a very important role, DCPO, DSW both in the rehabilitation. We are talking about one-stop crisis center, CWC. So representation of DCPO, CWC, DSW is very important in this meeting. So by the guideline, it's not there because it's a senior officers, even for the DALSA meeting, it's senior officers. So if that kind of...
Ma'am, just incorporate in that writing, that is what we have said, that whatever suggestions you are giving by way of writing, in that you just add, your group coordinator will give it to the director of the Odisha Judicial, will compile that on theme basis, this is the result, these are the flaws, this needs to be improvement. In that way we'll chalk it out and we'll hand it over to the concerned department so that it will be taken care of. Okay?
Sure, sir.
Thank you. Now the last questions we are taking from, so far as prior to this, Ghasiram Panda, Program Manager, please hand over the mic.
Thank you, sir. It is to the theme 2 who are dealing with the child-friendly procedures.
Yeah.
Sir, in many cases that those who are going to the court, if the friendly process, they are not acquainted with that or they are dissatisfied with that, here can we, the group 2 can add to this, can we mention the child-friendly indicators in local dialects in the court premises somewhere it is visible? And if they are dissatisfied in any way, suppose there are issues that they have to stay till the evening or something like that, to whom they will express that? So some contacts, numbers or details, if that can be available there, they can mention that the procedures, they didn't find it friendly. So there should be some rectification after that. So some kind of redressal approach, if that can be accepted, that is my point.
No, I think that is already laid down, but if you want that some particular way it is to be done, that child atmosphere, all this aspect, please give those suggestions in writing, because you are on telling about theme 2, I think, yes. So in your theme 2, please, so that it can be come in writing, so that accordingly we'll pass it on and appropriate steps.
I was in theme 1, so it's a suggestion to theme 2.
Yeah, right, it can be done. Okay, now you call these madams and...
We have with us respected Ms. Preeti Patkar, co-founder and director, Prerna Mumbai. Ms. Preeti Patkar has been working to protect children from human trafficking and commercial sexual exploitation and other child protection issues for over 30 years. She is a trained social worker and co-founder of Prerna NGO, a Mumbai-based organization that has led pioneering work to protect child victims of sexual assault and other vulnerable children from harm. May I now request respected Ms. Preeti Patkar, co-founder and director, Prerna Mumbai, to kindly address the august gathering.
Yes, this one. Will you just put it on? Yes, thank you. Thank you. Honorable members on the dais and all those in this hall, I want to thank everybody, UNICEF and Department of Women and Child Orissa, and the High Court Committee for inviting me and giving me this opportunity to share our work with UNICEF and Department of Women and Child in Maharashtra, and our on-ground work on working with children who have experienced sexual abuse. I also want to congratulate Orissa government on all their initiatives to protect children. I heard a lot about your initiatives when I was sitting in the subgroups. So congratulations on all the good work that's happening in Orissa. I got a lot of tips and I'm taking them back to Maharashtra. I will just start a little. I think I have 20 minutes and I'll try and finish in 20 minutes. I will start a little bit about our partnership with UNICEF Maharashtra and the Department of Women and Child in Maharashtra. We started work in 2015 working with a very convergence model and with different child protection functionaries for effective case management of Pocso cases. We've provided range of support to over 946 cases and have been appointed support person in over 107 cases between 2015 and 2021. We work towards a system strengthening by providing assistance and support to different child protection stakeholders, both government and civil society organizations, and have done some intensive work in over 150 cases currently. We've also conducted training on roles and responsibilities of support persons to the state appointed functionaries across the state of Maharashtra, trained police officials and other child protection functionaries. Currently, we are support persons in 34 cases and we have stopped taking support person orders, and I'll talk about why we've stopped taking support person orders. We created a learning and sharing platform called Pocso on the ground to facilitate a dialogue between different functionaries, both the state and civil society, focusing on challenges faced and best practices observed while responding to cases of child sexual abuse. The support person handbook, which was compiled by Enfold Trust based out of Bangalore with support from UNICEF India, we partnered with them by contributing our on-ground learnings. Currently, we've evolved a support person guidelines in Maharashtra in collaboration with UNICEF and DWCD and with inputs from subject matter experts. Prerna's understanding of support person's role has evolved by providing direct services of support person to children and their families, conducting regular trainings and providing hand-holding support to local child protection functionaries to build their capacities and as support persons, and I think most important, regularly taking feedback from children and their families and also other stakeholders and doing our best to incorporate those suggestions in our on-ground work. My sharing here today is based on all the suggestions that we've received from children, from their families, and other stakeholders like the CWCs, child care institutions, police officers, etc. Very often people ask, and this morning also we had this discussion on the importance of support person. So very often people ask why support person and what is the impact that a support person makes during their intervention, and how does it help children and their families. The support person has helped. This is again based on our experiences and what the children have told us. The support person has helped children navigate through the criminal justice system and enhance the recovery and rehabilitation of the child, thereby preventing further victimization, trauma, and harm to the child. The support person has been the much needed bridge between the child and multiple stakeholders such as the police, the court, the lawyer, the child's lawyer, the public prosecutor, the child welfare committee, and child care institutions. The support person has safeguarded the interests and rights of child at different stages of the legal case and liaison with the stakeholders on behalf of the child.
The support person has been able to assist the child in his or her journey through the criminal justice system. The support person has assisted to evoke beneficial provisions of the Pocso Act in the interest of the child. The support person has been a useful intermediary between the authorities and the child and assists the child through the investigation and the trial process. Here I want to say that the support person is not a caregiver or a caretaker of the child. Very often we talk of appointing support persons because we feel he will help or she will help give out a good statement, give out a clear statement. I don't think the role of the support person is limited to that, or the role of the support person is to attend as a caregiver in the hospital. So let's try and understand why the support person is important for the child and the family, and I think it is to support the child during the investigation and the trial period and not become caregivers. The support person has an intense long-term responsibility to render, and this is one reason why we've currently stopped taking support person's role. It is not about checking a box. It's not about checking a box to the CWC कि भैया हमने इतने बच्चों को support person appoint किया है, and it is not checking a box to a voluntary organization or any other stakeholder saying कि हमने इतने support persons के order लिए हैं. Remember, it's a very, very intense role. Very often we have experienced support person, including members from our team, experiencing secondary trauma. So it's not an easy task at all. Discussion on compensating support persons for their services is hardly being done. And I think moving forward, we do need to compensate support persons, need to further communicate the appointment of support persons to different stakeholders. This morning when we were discussing the, a lot of sessions court judges were saying there were some who were saying we've never ever had a support person come to our court. So I think the appointments probably are happening, but they're not getting communicated to the sessions court and other stakeholders as well. So moving forward, this definitely is something we need to do. Reluctance and apathy of CWCs in issuing orders of support person to victims of sex trade, victims of commercial sexual exploitation, children rescued from the sex trade. They are also victims of violence. There is a mention of them also in Pocso Act, and we need to do the right kind of assessment and ensure that they are also, if needed, we appoint support persons for them. I think there is a need to organize some kind of mentorship program for support person. Maharashtra did an amazing program of mentorship for CWC members. And on the same line, we've been talking to different stakeholders, and this is a suggestion that has also come from support person, if they can have mentors, because it's not an easy journey for them either. Moving forward a little bit about rehabilitation, again, appointment of support persons is linked to rehabilitation, though rehabilitation is not the responsibility of the support person. We should always remember rehabilitation is the responsibility of the District Child Protection Unit. It's the responsibility of the CCI staff in case the child is in the CCI. We should also remember that rehabilitation does not end, or the meaning of rehabilitation is not putting, admitting a child into a child care institution and then handing over the child or restoring the child to the family. Very often we think rehabilitation begins here and ends here. That's not what rehabilitation is. Impact of delays in prosecution and impact of pressures on prosecution both affect rehabilitation, and I'm bringing this point because of the delays in the trial that we are all experiencing. More than us, the children and their families are experiencing, and children find it very difficult to move on. For them, life just comes to a halt and they feel they want to do everything. Ek baar court kacheri ka chakkar khatam ho jayega. And I think it's so important we pay more attention to how we can complete trials at the earliest. Lack of information of entitlements is expected to be shared with the victims, as mentioned in Form A and B, as laid down in Pocso rules, is not happening. And this is something that I think we should, it's high time we started practicing this. There needs to be a paradigm shift from institutional-based rehabilitation to community-based rehabilitation. The minute the child is produced in front of the Child Welfare Committee, सबको लगता है बच्चे को shelter home, बाल गृह में भेजना चाहिए. I think we need to involve communities in rehabilitating children. We cannot invisibilize children. Community में लाओ ही नहीं ताकि उनका वो दिखे ही नहीं और उनका प्रॉब्लम भी हम देखे नहीं. I think we really need to move from there. Restorations to families is, like I said, is not rehabilitation. Importance of family strengthening from the point the child comes in contact with the juvenile justice system. ये अभी नहीं हो रहा है. We talk of जो कुछ थोड़ा सा बातचीत हो रही है फैमिली स्ट्रेंथनिंग को लेकर, I think it's all post restoration, whereas we need to start working the minute the child comes in contact with the JJ system. Mental health, I just want to bring this point here कि mental health professionals, we should not provide mental health support or counselors to children again ताकि एक अच्छा statement निकले. It is not about statement. I think mental health support is mentioned in almost all the documents you see related to child sexual abuse. It's with an intention to handle trauma. It's not about children giving proper statements, ideal statements. It is also about helping children heal so that they respond to rehabilitation, so that they respond and are prepared for prosecution. If there is no healing, I'm telling you, there's going to be no rehabilitation. And very often we use this term hostile victim, hostile witness, and we forget to see the reason behind that. The reason very often is because the child has not healed from the trauma, and also because very often for the child, justice is not trial and conviction. Very often justice is treat me with dignity, treat me with love, treat me with empathy, and stop my abuse. And I think mental health professionals help the child overcome all this that the child is experiencing. Because of the trauma, the self-harm that the child, the self-harm behavior that the child gets into. So mental health professionals are for that, and they are mentioned in all the documents. But like we discussed this morning, we constantly see either we have no mental health professionals, they are very, very centralized, the services, they are super expensive. Oh my God, mental health professionals are so expensive that I don't think if our clients were to go out and pay for the services, they would ever be able to afford it. I think the way forward is to train people in psychosocial first aid, to decentralize it and train, and not train ASHA workers. Okay, let's not put this burden again on ASHA workers. There are different child protection stakeholders. Let's involve them, train them in psychological first aid, and train all first responders. So don't think only police is the first responder. Many of us sitting in this room are first responders, second responders, third responders, fourth responders. I think all of us need to be trained in psychological first aid. So if at all we won't be equipped to handle trauma, but we at least can, with this kind of training, ensure we don't add to the trauma and the child does not experience several incidences that lead to trauma. I think there is a need to, like I said, train everybody in empathy, in compassion, kindness, being mindful. This is not expensive at all. Child-friendly procedures, I again, want to speak about dignity. I think we just don't understand the word dignity. We are only so focused on क्या ये ideal victim है, will this victim, is this a genuine victim, will this victim stay on till the trial period? ये statement तो ना बदलेगी. That is our focus, and our focus is very rarely just keeping the child at the center of all our intervention, having a very child-centric approach. Besides that, all the principles that we talk about, being non-judgmental, ensuring children participate in the process. हम बच्चों के साथ बात ही नहीं करते हैं, उनको पूछते नहीं है कि भैया तुझे क्या चाहिए. And I think we really need to move from painting the walls of our whatever facilities we create for children. I think children are okay if the walls are not painted. Children will just love it. I keep saying this, how often do we interact with the child and tell the child, Namaste, मेरा नाम प्रीति है, आपका नाम क्या है? It is always, तेरा नाम क्या है? अरे भाई आपका नाम भी बोला करो ना उनको पहले पूछने के पहले. So these child friendly procedures is what we need. We need to move from being decorative and tokenistic. Again, just respect and dignity, or we understand this automatically gets translated into our action. एक smile दे दो, पूछो मत बच्चे को ना कि ये तेरा फॉल्ट था, तू खुद ब खुद गई थी क्या, तेरी मर्जी थी इसमें. The minute we start asking these kind of questions, we stop being child friendly. There is also a provision of assistance of experts. In today's discussion, we've forgotten them. So don't forget them. There's a lot there in the Pocso Act for children. Let's ensure that we prepare the list of experts. Even in assistance of experts, there's a mention of mental health professional. Everywhere there is a mention of mental health professional, but we don't find children getting those services. लीगल असिस्टेंस की भी प्रावधान है, बहुत कम बात हुई है आज के दिन में उनके बारे में. सेक्शन 40, and I'm sure Ved ji will talk about it, how important it is to create this kind of awareness among children and their families that getting legal assistance is their right. विक्टिम कॉम्पनसेशन के बारे में बातचीत हुई, मगर हमारा एक हर स्टेट का एक फाइनेंशियल असिस्टेंस स्कीम भी है, एंड आई थिंक वी वर mixing the two. So we have victim compensation, we have the state financial assistance, and we also have special relief ka pravdhan abhi in Pocso rules, and we are not using, somebody in their presentation spoke about immediate relief, and the purpose of all these three is different, and the closest what we want is that special relief जो CWC तुरंत उस बच्चे को दे सकता है. But there is no provision for funds. CWC देने के लिए तैयार है, assess करने के लिए तैयार है, but they don't know from where to get the funds to give this special relief. So I urge everybody कि ये तीनों अलग अलग नज़रिए से हम देखेंगे, क्योंकि तीनों का पर्पस अलग अलग है. उसी के साथ children are not getting financial assistance. Victim compensation तो बात की बात रही, मगर जो financial assistance भी है state scheme का, वो भी नहीं मिलता है, because documents are not submitted on time, and because the families don't get support to create the much needed documents. जैसे आधार कार्ड नहीं है, बैंक में खाता नहीं खोला है. So there are times when compensation, the victim assistance is sanctioned, मगर महीनों it does not reach the child and the family because बैंक का खाता खोलने में किसी ने मदद नहीं किया. So these are the voices of the children and their family. Let's listen to them and let's support them, ताकि उनको उनके rehabilitation में जो compensation, very often children have to move, families have to move because of the threat, because of the stigma attached. This compensation will help that child. The child had to leave a public school, and now where the child has shifted, there is no nearby public school. So he or she has to get admitted into a private school. Yes, private school, जिसके लिए ये relief or financial assistance for that tuition fees, it will help. So let's try and help children. Again, I'm coming back to rehabilitation. I will not take more than 5 minutes. Rehabilitation cannot be incarceration, cannot be in the form of detaining a child, क्योंकि मुझे प्रोसीजर्स कंप्लीट करनी है, 164 स्टेटमेंट लेना है, मेडिकल करना है, and should not be seen as punishment. Today जो रोमांटिक रिलेशनशिप में है, जो बच्चे FIR बनता है उसके बाद, these girls are kept in child care institutions and the families are almost abandoning them, saying अच्छा है वहाँ ही रहने दो, अब सबक सीख जाएंगे. So these are not punishment centers. Institutions cannot further re-victimize children and add to their trauma. No, and we should also remember children, adolescents staying in childcare institution, there's a lot of stigma attached to it. No rehabilitation services for boys and non-binary children. सबको हमने एक कैप्सूल में डाल दिया है. It does not work. We need to now start talking about rehabilitation services for boys and non-binary children and how inclusive we are, how non-stigmatizing these would be. We don't want to create shelters whereby further stigma gets attached, but how can we have more inclusive services for them? MTP and adoption को लेकर भी I feel we need to talk a little bit more. हम MTP बोल देते हैं मगर उसके पहले और उसके बाद जो सपोर्ट की ज़रूरत रहती है, वापस जो मेंटल हेल्थ सपोर्ट की ज़रूरत होती है, एडॉप्शन, एवरीबडी काउंसल्स द चाइल्ड कि बच्चा हुआ है, तू इतनी छोटी, अभी एडॉप्शन को दे दो. And there are times when that kind of counseling, the child, finally says, मेरे को यहाँ से छुटकारा चाहिए, ले लो बच्चा, adoption को दे रही हूँ. मगर उसके बाद, where is the support system for the child? Who is helping the child? She is grieving. And we are not acknowledging her grief at all. After MTP, she is grieving and we are not acknowledging that. And when we don't acknowledge, we are not going to create those kind of services for them. Strengthening follow-up mechanisms. We have a beautiful section in JJ Act, section 37, जिसमें प्रावधान है follow-up का. मगर the most underutilized section in JJ Act and the most underutilized service of follow-up for the child under JJ Act. Finally, convergence and case management, काफ़ी कुछ कहा है, मगर इसके बिना I don't think हम कोई impact कर पाएंगे, हम बच्चों के साथ न्याय कर पाएंगे. वापस न्याय is not what happens in the court. न्याय is when the child heals. न्याय is when the child from victim in the true sense becomes a survivor. Not using the word survivor because we feel uncomfortable using the word victim. वो सही माने में survive होकर thrive होना है, जिसके लिए convergence और case management बहुत ज़रूरी है. Once again, thank you so much for patiently listening to me and giving me some extra 5 minutes, and all the best to all of us.
Thank you.
Thank you, ma'am, for sharing your valuable inputs on rehabilitation and reintegration of Pocso survivors and preventive measures. We have with us our esteemed guest, respected Professor Ved Kumari, Vice Chancellor, National Law University, Orissa, Cuttack. Professor Ved Kumari is former Dean and Head, Faculty of Law, University of Delhi. Professor Ved Kumari's area of primary academic interest are juvenile justice, criminal law, gender discrimination, clinical education, and judicial training. I now request respected Professor Ved Kumari, Vice Chancellor, National Law University, Orissa, to kindly address the gathering.
Good afternoon, everyone. Are we still all awake? I was sleeping occasionally. But post lunch, I had a very nice lunch. And so, in fact, I thought because it's the afternoon and you've been sitting here for the whole day working very hard, so I'll make it light and you will be participating. I do not believe in my conversation without your participation. So I think Preeti certainly made some very, very important point, and that reminded me to refer to the day before yesterday, Vidhi has released its report. Before that, Huck has released its report on functioning of Pocso. And these are important documents for us to look at. So I'll be referring to some of them, but I thought this is the winding up stage that we are reading to. You already are aware of the legislation. I'm not going to spend any time on this. I'm also not going to spend any time on this. This is just a recap of the legislation. And I know that you have been all working in the area, so you know all about this. But I thought it was still important to refer to some special features of the legislation, which is different from the other legislation in some senses. And some of them are problematic, and some of them we don't understand. When we say offenders under the Pocso Act are gender neutral, so are the victims, many times we don't translate into action, because constantly I keep on hearing that in case of consensual sex among teenagers, the boys end up before the JJB and the girls end up in the CWC. And I've never understood how is that happening, unless we do not understand what is meant by gender neutral. Why do we assume that in all consensual relationship of children, boys are the offenders? Why? If this is consensual, and we're saying this is consensual, then how can the boys end up before the JJP and girls end up in that? So I certainly think that that's something we really need to think about, that when it says gender neutral, it means gender neutral. So it's consensual, so either both of them are victims or both of them are offenders. It cannot be the girls are the victims and the boys are the offenders. That was the first point I wanted to make. And certainly compulsory reporting, if the child is found to be sexually active, is very, very problematic at the ground level. The point has already been made, and it's not at least at the medical practitioners level, it's not problematic because you just have to report. But at the judges level, it's very, very, very difficult, because then you are sending the husbands to 10 years of imprisonment. You end up sending the husbands to 10 years of imprisonment, because there's nothing else that you can do, especially if the husband is an adult. You got no discretion, nothing there, and they were validly married, and marriage is seen, even in the IPC, is seen as the only place for legitimate sexual intercourse. And there is a law which says, no, even within marriage you cannot have it. And therefore they end up trying to, sometimes convoluted reasoning as we say that, they say, no, because it's a personal law group, a minority group, they are entitled to marry at puberty, forgetting about that even in the marriage of Hindus is also a valid marriage. So will we say if a Hindu couple was there and the adult Hindu male and the minor wife, she became pregnant, now what will we do with that reasoning, because that doesn't apply to the Hindu couple. So there's a lot of things happening there, and that's certainly something which is very much on board. But as far as you are concerned, you are the implementators. At some stages, when your forums comes in where you can say, no, what changes we require, we will certainly want you to have an opinion, an informed opinion about what kind of changes will be required on compulsory reporting. There are pluses and minuses. Minuses are in the sense of this whole thing about the very harsh consequence which happens in compulsory reporting, and especially in cases where the teachers, where psychiatrists, where medical doctors, these are all people who are bound by they get information because of the trust reposed by the person concerned, especially the psychiatrists and the teachers. So they trust that information has come because of the trust, and then we have to validate that trust and tell the court and the police as a starting point. So that's something problematic. The positive part about compulsory reporting has been that we all believe that it is not psychologically, physically, mentally good for young people to become pregnant or get into such a relationship which leads to a lot of trauma at a later stage. So therefore we want to discourage that. And therefore if something is reported, if something is not reported, a lot of exploitation will go unreported in the under this non-reporting provision. So what we would want to think about is that there should be action but not penal action. There should be supervision, there should be direction, there should be counseling. So all that, the follow-up action on reporting should be different than what we have present. So there's something for you to think about and take your own positions. This is again another provision which is very, very unique. I think there is only one more legislation which has it, that it's only not only provides in cases of some of the offences that the burden of proof is on the accused to say that he or she did not have a sexual intent when the way where sexual intent is required, but this burden can be discharged only by proof beyond reasonable doubt. Otherwise, in all cases where presumption is shifted, the burden is discharged by creating a doubt. But this one goes step further, and that's pretty hard. And I think this is something which has been found necessary, but most of the time we're trying to find solutions to problems by creating principles which nobody believes in. And unless there is an acceptance of those legal provisions, they just remain on paper. We certainly know that there is a special court to try all offences, and many of you are here in that capacity. There is this provision for compensation, some clarity, some non-clarity. But what I wanted to emphasize was that even if the offender is not found or is acquitted by the court, the compensation can still be given to the victim girl or the boy, as the case may be. And support person has already been emphasized upon. And what I did want to mention is that in this study by Vidhi, they found that plus 90% of people were not aware of the requirement of using the support person on the list of CWC. So just as a quick question, how many of you in your court, how many are Pocso court judges here? Please raise your hands. थोड़ा ऊंचा से उठाएंगे, मुझे दिख नहीं रहा. So the Pocso, no, there's a whole, no, this is always affinity, na, पूरा Pocso court judges एक जगह बैठे हैं. So all these judges in have you had used protection officers in all your cases? How many of you have not used it in all your cases or any of your cases? Everybody has used you have not?
Protection officer are not coming. Protection officer are not coming to the court.
Not coming to the court.
But do you know they have been appointed in your case? And did you inform the CWC that the protection officer and the support person you have identified is not coming?
Even the interpreter, even the tribal ladies, where they are giving evidence, we are facing problems to interpret them.
So let's not extend to let's first focus on the support person. So because this is a support person which are identified by the CWC, and CWC is a sister body. So do you work with sister body or you don't? Or no, you said you only work with your sister judges and brother judges and sister judges, but not with CWC. They're not untouchables, na? Reach out to them and say what's happening, where is your personal support person?
They are not at all coming to the court. During my entire period of posting at my present station, I have never seen their face.
Sir, have you brought it to the notice of somebody?
It has been informed to their authority.
Which authority?
At Keunjhar.
Hanji?
Keunjhar.
We will see, ma'am. Just proceed. That's the one at the district. Ma'am, you proceed, ma'am, you proceed. We'll
no,
see.
but I think this is something which perhaps the committee can look into,
please
because
proceed.
unless there's coordination with three
Because
bodies.
At Keunjhar, we
So
have
three of you, the special court, the JJB and CWC
All right, please
have
take
to work together. You cannot say that, well, I will not look at or will not talk to them and I do not know. We need to create a mechanisms where there can be coordination among these three bodies. It's very essential. Okay. With the report, which was released just day before yesterday, and it's available on the net for anybody to download for free. They had actually looked at 3.5 lakh cases, out of which they analyzed 2.5 because other they had to discard for various technical reasons for the purposes of research. And in this one you can see that what is the conviction rate? 14% conviction rate in Pocso cases. So why is that happening? Are we saying all the other cases are consensual categories where the victims change their mind, or something else is happening here? This report doesn't tell us how many of the cases were consensual, how many of them were not consensual sex among teenagers. So we do not know have that information from this report. But the fact that ultimately at the end of the year and also they pointed out that there were 137 kinds of disposal in these cases. They reclassified them into 7 categories, and in that category they found the conviction rate is 14%. So I certainly think that if there's a 14% conviction rate, something needs to be looked at in terms of investigation, in terms of trial, in terms of evidence. And when I was hearing the presentations, my thought was, oh, everything seemed to be fine. So if everything seemed to be fine, everybody knows what the problems are, everybody had a suggestion to do that, so what is stopping us to do the suggestions? Why we want somebody else to provide those solutions? Can I find a solution for myself? I think that's important to ask that question. That among the list of suggestions every group has pointed out, which are the suggestions which you can implement yourself in whichever capacity you are, and which are the suggestions which have to be done only by somebody else. So I'm quite sure that something I can do at my level also. Let's focus then, let's identify that these are the things I will bring in my system, in my court, in my investigation, whatever I'm doing. And these are something which I require a systemic response from the High Court Committee, from the state government, from somebody else. So let's classify those suggestions into different categories and focus on that. Time taken, less than 1 year, 47%, 1 to 2 years, 2 to 3 years, more than 3 years. So I certainly think that's something which requires to be looked at again. And I did hear the parties say that this is the CFSL report. So CFSL are the biggest chunk of the culprits. They don't give us reports in time. And of course, the judges are not alone in deciding the time factor. There are always these other bodies which have a role. But one study which my student did in terms of CFSL functioning and all this DNA and all kinds of the other kinds of reports we require now on brain mapping and truth vaccine and all that. And we found that where the central CFSLs are, the high courts haven't used them at all. Not even one case is in some of the high courts where CFSL actually exists. So it is, I do not know to what extent it is the CFSL's existence or the number of it is partly certainly responsible, but also how many times you're using that. So okay, that was my presentation. Now your time. Some statements. Tell me which one are the correct statement, is the correct statement or correct statements. I do not know, maybe plural, single, is using it interchangeably. So what do you think? A, B, C, D, E. Please read. Can you read all? All of you can read? Or should I read out? Read out? For A, doctor need not report to the police if they find a married woman aged 17 years of age who had come for medical checkup to be pregnant. ये तो हमारा discussion हो गया, सबको पता आंसर. Yes, हाँ, इसका तो yes है, ये correct है. Sex with wife between 15 to 18 years of age is not an offense. Is that wrong? Sex with wife between 15 to 18 years of age is an offense only if it is non-consensual. ये भी wrong है. Sex with wife between 15 to 18 years of age is the offense of rape. And this is a tie between D and E. Sex with the wife between 15 to 18 years old is the offense of penetrative sexual assault. Whether both of them are correct, one of them is correct. D is correct or E is correct? Or more correct, both of them are actually correct, but actually E is more correct than D, because in the IPC, even though the judgment has changed it, this is the judgment, Independent Thought Procedure of India, when they said you have to read the age as 18 in IPC itself also, therefore both of them may be there. Okay, true or false, each one of these statements. All accused charged under any provision of the Pocso Act have to be tried by the special court under Pocso Act. One statement. Only adult offenders charged under provision of the Pocso Act have to be tried by the special court under Pocso Act. C. A woman of 35 years of age having consensual sexual relationship with a 17-year-old boy can be tried for an offense under the Pocso Act. D. A 17-year-old boy alleged to have committed aggravated penetrative sexual assault on a 10-year-old girl which resulted in severe injuries to the girl can be transferred to be tried as an adult by the special court under the Pocso Act. So A, false or true? एप्लीकेशन आ गया लॉ का, लॉ तो पता था हमें अभी तक. A, false. B, ये क्यों फॉल्स है भाई? क्या एडल्ट ऑफेंडर्स की बात हो रही है? एडल्ट ऑफेंडर्स की बात हो रही है. एडल्ट ऑफेंडर्स तो वहीं जाएंगे स्पेशल कोर्ट में. दे कांट गो एनीवेयर एल्स. The only distinction between A and B is because in A, children will also be there. When we say all. So therefore A is false. B is correct because certainly all adult offenders will have to be. C, woman of 35 years. Correct? True? Okay. D, D. हाँ जी, हाँ तो प्रिलिमिनरी असेसमेंट करके उसको स्पेशल कोर्ट भेज सकते हैं.
It depends on the findings.
हाँ, डिपेंडिंग ऑन द फाइंडिंग स्पेशल कोर्ट भेज सकते हैं क्या? Is there any Pocso court here who has dealt with a child under by transfer? नहीं कर सकते. It has to go to the children's court. But the transfer would still be the transfer is not to Pocso court.
No, madam, the Pocso court functions as the children court. So far as the Pocso cases are concerned, as per the definition of children court given in the JJCPC Act.
No, it's only that if children court is not appointed, then
No, madam.
Pocso or district court and the session judge can be treated.
No, madam,
as.
section 2 subsection 20 JJCPC Act defines a children court, either the children court designated under the Child Right Protection Act or the Pocso Act. So if the special court Pocso Act is there, then that will be the Pocso children court so far as the Pocso cases are concerned.
Section Pocso Act. कौन सा सेक्शन देखूं सर?
Section 2 subsection 20.
इसमें तो सबसेक्शन 20 है ही नहीं.
Section 2, madam, definition section. JJ Act, JJCPC Act.
JJ Act 220. Children's court means a court established under the Commission of Protection of Child Right or a special court under the protection of children from sexual offences whenever existing, and where such court have not been designated the court of sessions. So in all the districts, do we have children's court in Orissa?
Yes.
So if we have children court,
But in 23 districts there are special courts under the Pocso Act.
पॉक्सो के तो हैं, वो तो मैंने देखा. But whether children's court है?
Children's courts are there under designated under the Child Rights Protection Act. They are dealing with cases other than Pocso offences, like 302 cases.
Okay, so my mistake there, then that means your answer is yes. Though my answer says that it is false, but I stand corrected on this one, that it can be transferred after special assessment, etc., to the court. But my understanding was that the Pocso court comes into operation only if there is no children's court. If there is children's court already also in the state, then it doesn't go there, but perhaps you are right on this one. Okay, next one. In situations of consensual sexual relationship with children, the adult person, either male or female, is to be charged under the Pocso Act. ये तो yes simple है. Medical examination of a child above the age of 12 years may be done on the request of a child without taking the consent of their parent or guardian. B, consent of parent or guardian is required till the age of 18 years for any medical examination of the child. J, what's the question? A is correct and B is incorrect.
Yes, ma'am.
ऐसा कैसे हुआ?
Sir, for medical examination, age of consent is 12.
No, you are right, section 89 provides so. But section 27 Pocso says, without the consent of the parent you cannot.
If
And that is where the problem has arisen, and that's something for the High Court and the Supreme Court to do the harmonious interpretation. So then I'm hearing special provisions under the Pocso will override the general provision of IPC.
And her consent is no consent. This is a
Haji?
minority. Her
No.
consent is no consent till 18.
No.
No, sir.
No,
In
sir.
section 89, consent of the parent is required only if the child is below the age of 12 years. That has been the law all the while since till 2012. 2012 we got section 27 Pocso, which says any medical examination of children below the age of 18 has to be with the consent of the parent or guardian. So at that level there is one, this has led to many issues also, na? Illegal abortions. The girl could have gone, 17-year-old girl, if she become pregnant, she could have gone and sought medical support and taken some actions about that, or at least got herself treated or taken medical support. All that now she can't do without telling her parents, and she doesn't want to tell her parents. So she ends up without no medical support also. But so therefore, that's why I pointed this out.
Ma'am, for the risky procedure, any surgical procedure, they need to, there is a need of consent of the parents. For normal medical examination, they can do with their consent.
Sir, आप section 27 please देख लेंगे?
Ma'am.
हाँ, because it does not say medical procedure, it just says medical checkup. It doesn't say what kind. So any medical checkup also now for the children below the age of 18, you require the parents along with them. Okay, medical examination of the private parts of the victim is essential in all cases of penetrative sexual assault. Correct? Incorrect? Correct? Why it is correct? What is it that you want to find out for the medical examination? And that's an important question for us also know that even in case of rape, medical examination may not be required because it will not reveal anything. The definition of rape and penetrative sexual assault is not limited now to penovaginal intercourse. It can be an object, it can be a body part, it can be a finger. It can leave no traces whatsoever that penetration was there for medical evidence to give us anything. And it has changed in 2012 and 13 in this legislation and under IPC. The definition of rape as we understood it has changed, but it hasn't changed in our mind. We still believe, and a lot of us do believe, that if the girl or the boy has refused to go for medical examination, means they're hiding something. Medical evidence is not going to give you anything. So if it's not going to give you anything, why it is compulsory? It's something very important for us to remember. Second statement, two-finger test is illegal. Everybody knows that? Anybody who has a doubt? So if an illegal act is committed and you come to know of it, what will you do? You find that during the investigation or no, during the medical examination, a two-finger test was conducted on the girl. Is there anything you can do about it? Or should you do about it? I do not know the answer, I am just asking you because it came to my mind to ask you. What do you think? आप कुछ एक्शन लेंगे कि नहीं लेंगे? सुप्रीम कोर्ट ने लिया कुछ नहीं लिया जिस केस में लिखा इन्होंने टू फिंगर टेस्ट इज इलीगल. Did they write anything, any punishment, any proceedings to be initiated? Please try and find out. And then you can follow the same suit, or you can at least recommend that something needs to be done. Doctors can find if the offense of rape has been committed. Is it a correct or a wrong statement? I can hear a minority saying wrong statement. Can you sometime find?
Actually, so far as the evidence of the doctor is concerned, it carries importance only under section 45 of the Evidence Act.
Ji.
But still then the opinion of the medical officer is not final. That is not final.
No,
That
we are
is
not
only
saying it's
corroborated.
final or not, but can the doctor say, yes, rape has been committed?
Doctor may say rape may have taken place, but doctor can't positively and conclusively say that rape has certainly taken place.
Doctor, acha, next one. Doctors can find if the offense of penetrative sexual assault has been committed. Because when you, I wanted to emphasize that, the main point, that in rape offense, the offense is not sexual intercourse. The offense is sexual intercourse without consent. And doctors are not obligated at all to found whether it was consensual or not. They can say injuries were caused, sexual intercourse take place, but they cannot say rape was committed. In no case they can say so. But in some cases, doctor can mention that whether sexual intercourse took place or not. Because, not sexual intercourse, penetrative sexual assault. Because again, if some injuries have happened to the vagina which are indicative of that, they can mention it, but not in all cases. 17-year-old transgender person was subjected to penetrative sexual assault by his senior in college. The accused persons are punishable under Pocso or under Transgender Persons Act. G? Which one is the correct, A or B? Everybody clear? A? Or anybody has a doubt? Okay, should be clear, it's on a Pocso, and it's on a very tragic that under the Transgender Persons Act for the sexual assault, do you know what is the punishment? Up to 2 years. Really, you know, after recognizing human beings, transgenders as human beings, this is what we provide by law. So if this fellow turned out to be 18 plus, gone. So women subjected to rape, it's the same action, penetrative, anal penetration for example, is entitled to compensation, all kind of support, but transgender person, they still don't exist. Okay. This is kind of too many statements out there, but I think I'll let that pass because I've already been given the time warning. There are lots of compensation aspects here, and I have identified, I've picked up some of them. This is from the national scheme, compensation to the victims under Pocso Act. Whether any of these statements you can pick is incorrect. For the mental or physical harm or injuries suffered by the child, compensation can be given. To meet the expenditure likely to be incurred for medical treatment, physical or mental health. Correct. For loss of educational opportunity. Correct. Loss of employment. Correct. Only if the abuse took place over a period of time. वैसे ये incorrect है. So I'll just give you the answers also that these are the incorrect, that even if it is first time or whether over a period of time, compensation can still be given. So this I'll have to skip because too many reading to do, we don't have time for that. This again I may be subject to correction. Compensation is to be paid by special court, child welfare committee, state government, DCPU within 30 days from the compensation fund or the fund under 105 from the fine paid by the offender. Which ones are the correct statements? C by DCPU? C by the state government. E के बारे में क्या ख्याल है? ये भी correct है. F भी correct है. G incorrect है. It has to be ensured that all the fine is paid, but compensation is not to be paid to the from the fine. This I think is the last but one. Compensation to be paid. Okay, तो हो गया. False or true? All victims are entitled to receive a copy of Form A specifying entitlement of children who have suffered sexual abuse. Are you aware of Form A? Entitlement है? Do they have a? So in the view of this, is true. Are they entitled to all of them? E के बारे में क्या ख्याल है? List of important phone numbers including the district magistrate, superintendent of police. Are they entitled to it? The answer is yes. All of these are true. So this is we thought we still have some discussion points, some of the very crucial discussions which you cannot change, but I think you need to have an opinion. So as and when the occasion arises for you to contribute in bringing about changes, you can think about what will be your position on that. Sexual activities without marriage are illegal. What's your position on that? That's what a lot of I did hear somebody say, I forget now here or somebody, another meeting I had yesterday, we were having something, so they said premarital sex is illegal. So we need to think about that statement of ours. Age of consent for sexual activity should be lowered. Sexual activities between adolescents should not be punished. There should not be compulsory reporting by doctors, psychiatrists, teachers who receive information being in position of trust. So these are my suggestions for some discussion, but I'm quite sure that other points from your day's deliberations which have arisen for you to have a concluding position on. Thank you very much for this occasion.
Thank you.
Should I give it? Huh? Got it.
Thank you, ma'am, for your insightful talk and suggestions. The floor is now open for question and answers and group discussion. I invite questions, if any, from the audience.
One question has come from Rajeshri Das, and it relates to Group C, and can it is behind, mic behind it over, please.
Sir, I am Rashri Das, DCPO Koraput. Actually, in my district, recently one Pocso case has occurred, and now the victim is 2 months pregnant. But the termination of pregnancy, actually during the time of production before CWC, the parents and the victim, they want to abort the child. But now, as there is the only board in the SCB, so for the termination of the pregnancy, we have to send the child to the SCB only. So it is not possible on our part. This is very difficult to send from a distant place like Koraput to SCB for termination of pregnancy.
Okay, so you have written that in every medical college there should be medical board for termination of pregnancy.
Yeah.
That is your suggestion. We'll take note of that. Okay, thank you. So anyone can ask any question for. We'll take up 3 to 4 questions and then.
Sir, myself Director Family Welfare. Now presently only SC Medical College is functioning as the medical board for giving approval for these terminations, but we will be taking steps for extending to other medical
colleges. Right, because of the distance factor is from Koraput to this. Government colleges. Right, at least from in the government colleges.
Yes, all government medical colleges.
That's right. Thank you. It is now, I just want to have a open house discussion for 5 minutes. Now we find that there are many elopement cases, and where the victim girl is around 16 to 17 years, and it is of course the girl has attained the age of discretion, it is with the consent, he goes with the boy, stays there, and fathers lodges the FIR and case is instituted, but the girl is living very happily with the boy. So, whatever she has done with the boy, if we will see the Pocso Act, it amounts to the offence. So whether in such cases, whether the age of the victim is to be reduced or the punishment factor, because the minimum punishment is also prescribed for, that is to be reduced. It's a open house. What is your, because many cases which deal with, it falls within that category, that the victims are 16 plus 17 and elopement cases. So what is, anyone can give the suggestion that what should be done so that, please give the hand over the mic.
My lord, I feel that special statute may be enacted to take a liberal view and to give a power to the subordinate judiciary, to the special court, to release them under the beneficial provision of the PO Act, number one. Or else he may be punished with fine only. Or else he may be, he is at liberty to take the shelter of the honorable court under section 482 of the CRPC, because in my opinion, the purpose of the court is to give proper justice to the person concerned or for the larger interest of the society. In this case, when the parties are living together in a happy, cordial, conjugal atmosphere, excepting God, nobody will try to smash their family, to create further problem in the society, and there may be multiplicity of the proceeding. So I think these are the three issues which are coming to my mind. Thanks.
Okay. Anyone can give any other suggestion? Please.
My lord, these consensual sex should be excluded from the purview of the Pocso Act by separate legislation, and age has criteria to be fixed, that may be above 16 or above 15, like that, and these cases to be excluded from by special statute.
Don't you think that by doing that, this sort of offense will increase in the society? College girls will go away with the boys, and there will be, they will free to do it.
My lord, many of these cases end in compromise.
No, I'm not telling you. Please see the practical reality. Think of the mind of the parents. So they have grown of a girl, and the girl has attained the age of 17. Please away with the boy, just young age, young age romance, I can say, it will be over within 1 or 2 years. Boy is not doing anything. So in such a situation, if whatever you saying, if it is legalized, then what will happen to the society? Because this type of crimes are coming off in this. One side, whether it is to be the punishment is to be reduced, or such type of thing is to be totally wiped out, consensual sex in such a case, 16 plus, which, and what would be its impact on the society? I am just opening of it.
Sir, can I come?
My lord, even if there is stringent punishment after 2013,
I'll ask ma'am. Just, yes,
even if there is stringent punishment after 2013 Nirbhaya case, the Pocso Act have been amended, but no change is there. Number of cases is not lowering.
Okay, ma'am, please.
Just to weigh in on this topic, I think there are two things, right? We do recognize that there is an increase, and a lot of cases in Pocso are actually what turn out to be consensual or elopement cases or romantic cases, as we call it. Whether approaching them only through a legal lens is the right way is also a consideration for us as a society to take, that should all these cases be dealt the legal way? Isn't there a way for counseling and sitting with families and children and, you know, perhaps undoing some of the damage? The second aspect is that we cannot also overlook adolescent sexuality, curiosity, and their natural, sort of behavior in this phase. And is it appropriate to criminalize them? That is also a question we should ask. Perhaps what is needed is a lot of prevention activity, better comprehensive sexuality education in schools, engaging with adolescents about safe, unsafe behaviors, and being able to also provide them these services for protection. but not really to look at everything through a criminal lens. Having said that, I'm also not saying that the age of consent should be blanketly reduced or whatever, or there should be a blanket sort of dismissal of cases in this bracket, because even within that there will be cases which are actually really abusive, right? But there has to be some thinking around how the law can cater to this larger proportion of cases which are turning out in all acquittals. 90% of these cases turn out in acquittals. And, and keeping still a provision for the criminal action where it is actually required. So that is a larger debate. I think in the recent times, a lot of the high courts have also reflected on this in various judgments about, how appropriate is it for us to have this blanket criminalization approach vis-a-vis a more balanced approach between social, criminal, and thinking about how the law can be more flexible.
Okay, thank you. Because they find that they have taken this 18 because they think that at a particular point of time, at that age, he is become more mature to know that what is the, but time has changed, and again anyone can, before we close up and we'll start to the next one, anybody wants to highlight on this particular aspect. Teenager love story, elopement case, girl is 17 years, goes away with the boy, living very peacefully, happily. Father lost the FIR, and what would be done, whether there would be any necessity, the change of the legislature or reduction of punishment. Anyone can just tell, and otherwise we will conclude it. Just think over it because the problems are coming in society nowadays on this particular issue. More and more number of cases are being registered nowadays. So if you can find time, think over it and give the suggestion, address to the director, so that we can write it to the appropriate agency. Thank you very much. Proceed.
With this, we come to the end of the group discussion. As a token of our respect and appreciation, we would like to present a memento to our esteemed guest. May I now request Honorable Sri Justice Sangam Kumar Sahu, Judge and Member, Juvenile Justice Committee, Orissa High Court, to kindly present a memento as a mark of our appreciation to respected Professor Ved Kumari, Vice Chancellor, National Law University, Odisha, Cuttack. May I now request Honorable Sri Justice A.K. Mahapatra, Judge and Member, Juvenile Justice Committee, Orissa High Court, to kindly present a memento as a mark of our appreciation to respected Ms. Preeti Patkar, Co-Founder and Director, Prerna, Mumbai.
He will take.
Thank you, my lords. As we come to the end of the program, I request Honorable Sri Justice A.K. Mahapatra, Judge and Member, Juvenile Justice Committee, Orissa High Court, to kindly present the concluding remarks. My lord, please.
You all must be wondering that another Gyani has come to deliver Gyan. After such a long session. In fact, I think it is one of the longest session which I have attended. Same must be the case with you all. One of the longest technical session. In any case, ritualities have to be followed. I'll conclude. I assure I'll conclude in 2-3 minutes. I'll not keep you waiting for long. I start with Justice Devrat Das, my elder brother, Justice Sangam Sahu, Justice Raman, then Madam Bed Kumari, sorry, Justice Rath, my sister, Madam Professor Bed Kumari, Madam Naidu, Patka, then all you dignitaries, guests, all members of judicial fraternity, PMJJB, CWCs, everybody whom I have left out, please forgive me. Within the short time, whatever names, whatever is coming to my mind, I have addressed them. So here I will start with suggestions are many. So we have taken note of all that. On the basis of the suggestion, we have to prepare a checklist and to review it from time to time, and we have to tick the boxes as to how much you have incorporated and implemented. So it requires a continuous process. Therefore, I am not, although I have prepared a written speech, I am not going to read out that. So you all will be bored and I will get a good beating at the end. Some of the points. So what is the most important aspect? I found that these two special acts, those have been carved out from the general stream. There are 5 stages according to me. This is my view. First step is prevention. The second stage is early detection and reporting to the police. Third important aspect is investigation, early investigation, because sometimes in most of the cases the evidence gets destroyed and cases end up in acquittal. Then the fourth stage is early trial. That is the essence of those two statutes. It has to be concluded within the stipulated period of time. That we have not been able to follow in many cases, which is one of the aspects which are also focusing at the High Court level. Then the next is rehabilitation, compensation of the victim to bring them back to the society, to rehabilitate them is one of the most important aspects. Here in this context, in a lighter vein, I would just give an example. You all must be following cricket. So criminal trials like murder, rape, dacoity and other cases, those are like test matches. When you come to considering bail applications, those are like 2020. So now what this Pocso and JJB, these are a special category. These are like one-day matches. So limited over, you have to play well, and most importantly, you have to play as a team. And team consisting of state, judiciary, then UNICEF, then other CWC, all those volunteer organizations. So everybody has to perform. Then only we can achieve the target, desired objective. And so far those presentations are concerned, those are all wonderful. So everybody must have taken note of all those suggestions made by the group members. So I congratulate all the group members for preparing such nice presentations. So we have also taken note of, and I also once again request you all to give in writing your presentation and suggestions, so that we can prepare a detailed report on that and prepare a checklist, some of the things which are to be followed, because it's a huge challenge. So we need to work as a team. When we go to the state government, they will say challenge is huge, expectation is huge. There are fund constraints. Fund need to be provided by the state government and other agencies. So within the limited resources also, we will try to achieve our target. And before concluding, I must say that we all are doing a good job. So we must try for the best, the great. So for that we need to act as a team and incorporate the ideas which we have discussed in our interactive sessions and try to adopt some of it. But so far judicial officers are concerned, I must say that we must stick to our basic job. That is my principle in life, that the basic duty is we must try to conclude the trial within the time stipulated. Unless we do that, the fallout is very serious. Evidence gets destroyed, the accused, they don't appear, the witnesses are lost. So ultimately, the whole thing is ends up in a mess. So my request to all the courts, children court and the Pocso courts, to conclude the trial within the time stipulated. Of course, the COVID pandemic, that was a constraint earlier. Now everything things are clear. So we'll try our best as a team to expedite the process and conclude the trials, pending trials, as soon as possible. With these words, I take leave. Thank you. Bande Utkal Janani, Jai Jagannath.
Thank you, my lord, for sharing your valuable thoughts. May I now request Honorable Sri Justice M.S. Raman, Judge and Member, Juvenile Justice Committee, Orissa High Court, to kindly present the vote of thanks. My lord, please.
We are supposed to end it.
Namaskar to all. At this high tea time, I may not bother you much. Having given anxious attention to the cause of juvenile today towards their care and protection, we have heard the voice, we have started hearing the voice of children saying, shatter the silence. At the end of today's consultation program, when I am to part with, I feel extremely honored to propose a vote of thanks to this eventful occasion when we are assembled here to discuss the ways and means to nurture the juvenile to tread on the right path. To assess success of a roadmap made for children, follow-up is the only way to do so, that is this event. During the progress of various sessions today, we all have had good and great occasion to share views and candidly contribute to this consultation. I, as a member of Juvenile Justice Committee, on behalf of all of us here, particularly sister and brother judges, extend heart gratitude to Honorable Dr. Justice S. Muralidhar, the Chief Justice of our High Court, who is the constant source of guiding force for organizing this consultation. I express my heartiest gratitude to His Lordship's constant monitoring and showing finesse to the subject under discussion, enthused inspiration in all of us, which enabled us to carry the torch ahead. I may have this opportunity to extend the vote of thanks to esteemed brother Justice Honorable Devabrat Das, Judge, High Court of Orissa, and Chairperson, Juvenile Justice Committee, High Court of Orissa. It is not out of place to be thankful to sister and other brother judges of our own High Court for sparing valuable time amidst busy and hectic schedule, for having lent keen ears during different sessions held today. I extend special thanks to Srimati Shubha Sarma, Commissioner cum Secretary, Women and Child Development Department, Government of Orissa, Sri Arvind Agrawal, Director ICDS, Srimati Rega Geeta Rani Patnaik, Additional Secretary to Government, and their team for not only extending their cordial and instantaneous support, but also in making today's event a grand success. I also extend vote of thanks to the dignitaries from the Department of School and Mass Education, Government of Orissa, different departments of Government of Orissa. I extend my hearty gratitude to the eminent resource persons and the experts whose valuable insight has immensely benefited all of us, particularly the stakeholders. I thank Professor Ms. Ved Kumari, Vice Chancellor, National Law University, Odisha, Cuttack, and Srimati, particularly Preeti Patkar, co-founder and director Prerana, Mumbai, for gracing this occasion. I acknowledge my sincere gratitude to Ms. Tanishta Datta, Child Protection Specialist, UNICEF India, Mr. Sugata Roy, Officer in Charge of Field Office, UNICEF Odisha, and Ms. Neha Naidu, child protection specialist and the team UNICEF for their persistent support leading this state level consultation on effective implementation of Pocso Act to grandeur. I extend my vote of thanks to the chairperson OSC PCR for gracing the occasion. I extend the vote of thanks to Registrar General and members of the Registry of our court. I extend the vote of thanks to the Director of Public Prosecution for his support. I also extend my vote of thanks to the Director, Odisha Judicial Academy and his team to have arranged such a function and smoothly organizing the event and having made the arrangements for the guests and invitees. I extend my vote of thanks to the Member Secretary, Odisha State Legal Services Authority and his team for their support in organizing this consultation. I also thank the members of Secretariat, Juvenile Justice Committee, High Court for their relentless efforts to make this event a success. I convey my gratitude to the participants, the judges of Pocso Court, the PM JJBs, Secretary DLSS, the public prosecutors, the chairpersons of CWCs, the representatives from Special Judicial Police Unit, DCPOs, DSWOs, members of one-stop centers, medical practitioners, the officers from SARD, SERT and the representatives from NGOs and civil society organizations. I can't forget to express my thanks and gratitude to all other dignitaries and guests present in this auspicious occasion. Your benevolent presence has marked significance in instilling positive thoughts in all of us towards a great beginning. I propose the vote of thanks to the members of print and electronic media and all those who have toiled hard to make this function not only a success but also added flavor to success. Before taking permission of the chair to close the program, I must say the participants and resource persons have contributed to the valuable discussions and ideas which are extremely important for us. They have made it successful with interactions and sharing thought through examples from the field. I am sure every single person, including students of law present here in this august gathering today, is committed to advance the cause of children subject to abuse and conflict in law and their rights and rehabilitation. Let us hold collectively responsibility for the children's rehabilitation, social reintegration and betterment of their future to guide and build the nation as strong and fearless. Thank you all. Jai Jagannath, Jai Hind, Vande Utkal Janani.
Thank you, my lord, for your kind and inspiring words of appreciation. I would now request the Honorable Chair to kindly declare the program closed. Thank you, my lord. Before we leave, may I now request the guests on and off the dais, participants and the audience to kindly rise to pay respect during the rendition of the state song Vande Utkal Janani.
Vande Utkal Janani, Vande Utkal Janani, Vande Utkal Janani. Charu bhasamai, Janani, Janani, Janani. Vande Utkal Janani, Vande Utkal Janani. Payodhi vidhauta
With this, we have come to the end of the program. I request our honorable guest to kindly join us for high tea at the first floor, and I request the respected dignitaries to kindly join us at the ground floor. Thank you. Namaskar.